Greetings, greetings, greetings. Thank you so very much for joining us. My name is Nana Jumphy, and I am the president of the National Conference of Black Lawyers, the legal arm of the Black Liberation Movement, and we're so pleased to have you join us today. We are, it's an intimate team, an intimate crowd, which is the way we like it. We're hoping that that will mean that we'll have great discussion, that we'll have good questions, because this program is one that is very important that we see, and we hope that you'll see, is a critical part of our liberation struggle. The Law Enforcement Accountability Project was put together to assist Black lawyers, young lawyers and not so young lawyers, who are interested in being on that legal front line in support of Black folks who have been injured, maimed, or killed by police. We know, we can look at the headlines and we can listen to what we hear from our community members, our comrades, and our friends about what is happening with the police and Black people. And we know that this is not a new story for us. This is something that we have been dealing with as Black folks since the very beginning, and certainly NCBL has been dealing with this since the beginning of our inception. And so we're very, very pleased to have this program going under the stewardship and leadership of our great comrade, Lennox Hinds, who will be joining us shortly, to make sure that we continue to develop the kind of legal expertise, the kind of legal warriors that can be out here in this particular type of fight. And so we want to begin. If you look at your program, hopefully you all have those materials. The material should include a program. You should have information that has been provided by the various presenters. We will be providing information later about what you need to do in order to make sure that you get some CLE credit, or MCLE as we call it out here in Cali, credit for attending. But even for those of you who may not be attorneys, but are law students or others that are interested in this topic, it is going to be well worth your time. I'm so very pleased to start with our esteemed colleague, Professor Irving Joyner. Professor Joyner is a professor at North Carolina Central University School of Law, and he's also the legal counsel for the North Carolina NAACP. We're thrilled to have him. He is one of our faculty members where, folks can't stop taking the notes. Hopefully he won't hurt us too much with all the information that he has. He's going to be talking to us today about actionable conduct and giving us some background and scope on 1983 cases. Thank you so much, Professor Joyner.
Okay, good afternoon to you. I'm still kind of foggy. Depending on where you are located, whether it is morning or afternoon. But since I'm on the East Coast and East Coast time, it's good afternoon. For those of you who are on other times, it is probably good morning. But it's good to be here with you. And it is certainly great to be able to talk about this particular topic. It is one that is a godsend in litigating against police misconduct and official misconduct by people who are in positions of power within our country, and gives to individual an avenue toward redress of grievances that they have. Let me kind of take us back. And I know that none of you were there, nor was I, in 1871. That's not 1971, but 1871, when the Congress created the Civil Rights Act of 1871. It's also called the Ku Klux Klan Act. And this was a part of a wide range civil rights bill that was introduced and enacted in Congress for the purpose of protecting the newly freed African Americans to guarantee that their rights would be protected. And in the event that there were violations of those rights, that those individuals would have redress opportunity by going directly into federal court. And at the time, it was felt necessary to provide this federal remedy because you could not trust state courts. You could not trust state courts to vindicate the rights of these newly freed African Americans, especially in the South. By 1871, the Southern rebelling states, those states that had left the Union and had waged war against the United States, had been readmitted, and readmitted typically under in a situation where there was significant participation by African Americans in the drafting of the state constitutions, but the court system was still not fully developed such that the rights of these Africans could be secured. And therefore, Congress thought it necessary to create this federal remedy. And this federal remedy allowed for people who were the victims of official misconduct, to take their claims directly into federal court. And that was the genius of 1983. Also enacted during that same legislative session was 42 USC 1981 and 42 USC 1982. And those dealt with private remedies where there was a violation of either contractual rights or the ability of African Americans to enter into contracts at the same level as whites, or in the case of 1982, protection of property rights. So you had contract rights, which became a separate personal right, and property rights, and that was the ability to purchase land, to use land, to transfer land, and where there was a violation of the rights of an African American to do so, then that claim could be brought under either 1981 or 1982. But separately carved out were those situations where official state action was involved in creating the tort or creating the claim. So we call them today constitutional torts. Constitutional torts. Looking at your manual that you should have received, the Civil Rights Act of 1871, says that every person who under color of any statute, ordinance, regulation, customs, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other persons within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress. Now, just kind of looking at that, there are few things that differentiate 1983 from your common or ordinary torts. And I know that those of you who've been to law school and had the terror being engaged in the torts class and all of the various common law and statutory torts, you're not in a position now that you want to hear a lot about torts, and I'm going to ensure that you don't hear a lot about torts, and that's why we're looking at constitutional claims. Constitutional claims, claims that are created pursuant to some federal enactment, some law that was designed to protect the civil rights of individuals and to provide a remedy where there was state action. There was state action. So we need to talk about that. So any person who is aggrieved, the statute talks about a citizen of the United States, but also any other person who is present in the United States. Any other person who is present in the United States, the contiguous United States, or United States possession. So you don't need to be a citizen to have a 1983 claim, because the Constitution provides protections for every person who is in the country and not just citizens. So we're moving past the narrow confines of citizens, but clearly citizens are a beneficiary, as are any other visitors, long-term or short-term, into the United States. Then it talks about under color of law. Under color of law. Under color of law refers to those situations where a person is placed in a position of authority as a result of some statute, ordinance, regulations, custom, or usage. They are placed in position of authority. And with the authority comes responsibility and accountability. Because when the person is placed in this position of authority, they are then clothed with the authority of the state to take some action against individuals, some punitive actions in many respects, certainly restraining and refining actions against an individual, because they are given power over the ordinary citizen or other person who is in the country. An example of that is a police officer. A police officer is acting under the color of law. The police officer is given authority by statute. Where whatever state you are in, you can find that there is a statute which gives to police officers certain authority after they have been sworn in as officers and they have been employed in that capacity. That constitutes action under the color of law. But it's not just restricted to police officers, because there are other governmental officials who operate and act under color of law because of the authority that's given to them by the statute. Now, what I want to do at the outset is to spend a couple of minutes and just kind of talk about those situations where the color of law does not apply. There are immunities that are grafted into the United States common law. And those immunities follow into 1983 litigation, such that there are some people who are clothed with governmental authority, but they are representatives of the sovereign. They are representatives of the sovereign. And those of you who have taken constitutional law know that within our body of law, the sovereign cannot be sued by individuals because it is deemed that the sovereign is composed of individuals, that the government is the government of the people, and the people can only be sued when the sovereign allows them to be sued. But it also creates a class of individuals who are a part of the sovereign who cannot be sued as long as their conduct is within the scope of their authority. So as long as their conduct is within the scope of their authority and they are representative of the sovereign or their position designates them as merely a substitute for the sovereign, then they have immunity, which means that they can't be sued. Like the governor. The governor. The governor has sovereign immunity and cannot be sued for money damages. For money damages. Can be sued for injunctive relief, but not for money damages. So there is this notion of sovereign immunity. Then there is this notion of executive immunity. Executive immunity. That's the kind of immunity that would attach to, for instance, the president would be, or the attorney general would be the recipient of executive immunity. But because of their position as the leadership in one of the normal agencies of the sovereign, and they are engaged in activities that are commanded by their position, then they can't be sued. And the rationale for that is that these individuals should not be in a position that they are regularly harassed by people who file lawsuits against them, and they are unable to carry out their duties because they have to respond to these lawsuits. No matter what you think about that justification, it exists, and so these individuals cannot be sued. Legislators, under the guise of legislative immunity. Legislators who are elected and in office or in the legislative position, as long as their conduct is in pursuit of their position as a legislator, then they are immune from litigation as a result of that. Judges, judicial immunity. Judges cannot be sued because of decisions that they make that are within the scope of their power and authority as judicial officials. The district attorney is an executive officer or a judicial officer and cannot be sued on an ongoing basis for the decisions that they make. I want to get them off the table so that you know that our conversations don't relate to individuals within that class. But every other employee or actor in the system is subject to suit for their misdeeds, for their misconduct, where there is injury attached on behalf of the people. And once we get to that, it's pretty broad. 1983 was enacted in 1871, but basically stayed dormant until the 1960s. It laid on the table. And actually, it was a law professor at Rutgers University, Arthur Knoy, and some of his students who discovered in the beginning of the 1960s this legal device that could be used. So the first case where this notion was advanced in the U.S. Supreme Court was Monroe versus Papp, and that was in 1961, where the court agreed that the individuals who had been harmed had a right of action against uh, the person acting under color of law, which caused them harm. Notwithstanding that, they then declared that a municipality did not come under the guise of a person. It was not defined as a person. And that failure to recognize municipalities as a person hindered the growth and development of 1983 until 1978, when the Supreme Court decided a case called Monell versus New York City Department of Social Services. And in that case, the Supreme Court went back and redefined what constituted a person and defined municipalities as a person. And it makes sense when you look at the history of corporate law in this country, where a corporation is given, it becomes a kind of an artificial person. It is given the status of a person. So a corporate entity, and that's what a municipality is, because it is a creation of the state. Just like any other corporation, it has to apply to the state for corporate recognition. And once corporate recognition is given, then it operates as a person or as a unit. So in 1978, the Supreme Court recognized that and defined municipalities as persons under the law, such that now you could not only hold individuals liable for their conduct, but you could also hold the municipality liable for that person's conduct in any number of different instances. Now, the actionable conduct that flows under 1983 is broad, and you can really kind of track it from the Constitution. So whether we're talking about a First Amendment violation, freedom of speech, freedom of press, freedom of association, the right to redress grievances, to protest, to associate, to organize, all of those provides actionable conduct that can be brought under 1983, where the offending party is a person who is acting under color of law. Clearly, Fourth Amendment violations. That's stop, search, seizures, false arrests, false detentions, abuse of persons who are held within the control of the state. Fifth Amendment violations dealing with forced confessions, and Sixth Amendment violations dealing with trial rights involving the right to counsel, the right to trial, the right to jury trial, the right to confront accusers in the criminal process, down to the Eighth Amendment, where we're dealing with cruel and unusual punishment. So no matter what the constitutional violation is, there is a claim available under 1983 if the harm is caused by someone who is acting under color of law. If the harm is caused by someone acting under color of law. Now, 1983 is broader than just the Constitution, because it also involves any statute, any federal statute, ordinances, regulations, or custom of the state. Case in point, Title VII can provide a basis for a 1983 claim, where the Title VII violation is caused by a person who is acting under color of law. So not only do you have a Title VII violation, but you also have the ability to bring a claim under 1983 and take that case directly into federal court. One of the great things about 1983 is that you don't have to exhaust state remedies, unlike Title VII, unlike Title VII. But for employment discrimination by a state actor, you can go directly into federal court under 1983 because that is a contract violation, but where it is caused by a person acting under color of law, then it becomes litigatable under 1983. So it's a very broad cause of action that allows you to reach out within limits where there is this population that is causing the harm, where they are utilizing their power as a governmental employee to cause harm to everyone. Now, every employee of the state would not be acting under color of law. Every employee of the state would not be acting under color of law. Case in point, a groundskeeper working for the state or working for the city is not acting under color of law, even though they are an employee of the state, a file clerk or a somebody working in the warehouse to store goods purchased on behalf of a state agency. They would not be operating under color of law because they don't have authority over the person. They are not clothed with governmental authority or governmental power to control the activity of individuals. So when we talk about color of law, we have to ensure that we're talking about someone with the power over over other individuals. The different areas that the court has recognized as being actionable conduct are set out in the manual beginning at page 2. And they go on and they form those familiar causes of action that we run into, that we encounter as we work through the process. But these are just illustrative of the many causes of actions that that exist within the power of 1983. So it's a very powerful tool that you should be able to use. Now, another piece that I want to just raise with you is the what I call the incentive to engage in 1983 litigation. And you're going to get into more of that discussion later on today. And that is found under the aegis of 1988. And that's called the attorney fee provision. The attorney fee provision, which gives to individual lawyers the ability to act as private attorney generals, to bring actions on behalf of the people who are injured. Oftentimes, those individuals who are injured don't have the means to go forward in litigation against the state or against some state actor. So 1988 provides an incentive that where the lawyer reaches out and seeks to protect the rights of the individual, and they are successful in that litigation, then they are entitled to attorney fees and any costs that or expenses that they have incurred during the process of that litigation. So it provides at the end of the day an opportunity for the attorney to be handsomely compensated for their actions. And the amount of that is dependent upon the novelty of the action, the difficulty of the action, the time put in into litigating the case. But you look at the fee scale of other individuals within that jurisdiction or the jurisdiction that you are in to determine just what the prevailing rate is for this litigation. So this is an incentive to litigate 1983 cases because statutorily there is an attorney's fee provision that attaches to the claim. Now, I mentioned the individual liability. I also mentioned the municipal liability. And in certain areas, the municipality can be held civilly liable for the conduct of people that they place into positions of control and authority over individuals. The municipality is not subject to punitive damages. The municipality is not subject to punitive damages. However, the offender, the tortfeasor in this situation is liable for punitive damages. So punitive damages can be assessed against the person who has caused the harm, but not against the municipality. Nevertheless, in many of these cases, the municipality provides the deep pocket because they typically will indemnify. They will indemnify the employer against any legal liability that that they encounter along the way. So with that, I'm going to just stop at this point to see if there are any questions. I would reference you to the manual, particularly through pages 2 through 20, that reiterates many of the points that I've made. We are always available to you to help you to better understand how this 1983 litigation works. There will be additional instruction for you later today on other aspects of litigating these 1983 claims, but it is a godsend if you use it in the interest of protecting the interests of the people who are without the means to protect themselves. So let me stop here, Sister Nana, and see if there are any questions.
Thank you so very, very much, Professor Joyner. You know, I've heard it before, and every time I get a new note, a new thing that I think about, a new connection that's made. Really, really appreciate all of that wonderful information. I see that our esteemed comrade, Lennox Hinds, is on, and I'll turn it over to him in a moment, but do want to, with this intimate crowd, I think we're able to ask questions directly. If folks have questions, I know there's also questions in the chat, but if folks have a question, Laura, I see you have a question. We don't have a lot of time for questions, so if you can make it as succinct as possible, that would be wonderful. But if we're able to hear folks' voice, we'll do that. Go ahead, Laura. Okay, we can't hear you. So I'm going to ask the question that I saw you ask earlier, which was, Professor Joyner, a question about whether or not police chiefs, mayors, folks in those positions, do they have liability under 1983? This was when you were giving the list of who don't have liability. So who does have liability when it comes to chiefs, mayors, etc.?
The chief would be immune, as would the mayor. And in some instances, police officers for various types of conduct would enjoy what is called qualified immunity or good faith immunity. You're gonna get into more discussions about that later on, so I don't want to go too deep into that. But the person who is at the top of the pecking order, the mayor, the city council people, they would fall under either the executive immunity or the legislative immunity if they are in the position of making the laws or developing the ordinance or regulations that are in place. Typically, 1983 would involve those situations where the people are implementing and enforcing those laws and regulations, and the breakout from that would fall in with municipal liability under certain circumstances.
Thank you so much for that. Oh, there, Laura, we can hear you.
Thank you. I appreciate that. Sorry.
No problem. Thank you so very much. Thank you for submitting the question. Thank you for joining this conversation. Desiree has a comment. She says, not a question, but her comment is that was an excellent overview, which will be very helpful as my office is embarking on this type of litigation. Thank you so much, with an exclamation point at the end. And we're so glad. Go ahead, Professor Joyner.
No, I just say good luck with you to you on that, and please be forceful and robust in your efforts to hold the offenders actionable for that conduct.
Yeah, you use two words that are definitely our comrade Desiree, so we ain't got to worry about that. She's going to be fighting with everything she got, she and the team. And so really glad. And again, this is the goal, is to provide information that folks can use so that they now can be in those courtrooms doing this work on behalf of our people. For all the cases that we hear about, we know there are so many cases that we don't hear about. And, it's not going to do for 3 lawyers to do them all, right? We've got to make sure that other lawyers are involved, and particularly lawyers that are connected with our movement. Professor Joyner, there's a question as to whether or not folks can get your email address or contact information for you.
Joyner, that's IJOYNER, at nccu.edu. Joyner at nccu.edu.
All right, folks, and I'm putting that in the chat right now so that folks can copy and paste it while we see if there's any other questions. And if not, I'm going to turn it over to Baba Lennox. Any other questions that folks have? I don't see any other questions in the chat, nor do I see any other questions in the Q&A. And so I think that it's an appropriate moment to turn this moderation over to Lennox Hinds. You're on mute.
Can you hear me?
Yes.
Thank you very much, Nana, for your excellent MCN. And also I'd like to thank my colleague, my esteemed colleague, Professor Joyner, for the excellent overview, setting out the scope of the Civil Rights Act, jurisdiction, liability of defendants, and dealing with pending jurisdiction. All of you who are now attendees should have had the litigation manual. That manual, if you go from pages 2 to 20, should cover all of the cases and the issues that Professor Joyner provided. So if you took notes, they could supplement what is in the litigation manual. Okay? Now, you must have been told that Professor Joyner has over 34 years of teaching experience, and our combined faculty have close to 200 years of trial experience and teaching. So this is a master series that we have here. You know that Professor Joyner teaches criminal law, criminal procedure, civil rights, professional responsibility. He has published 3 editions of his book on criminal procedure. And of course, he was identified and awarded as a Lawyer of the Year at the George H. White Bar Association in Durham, and Professor of the Year by the students at North Carolina Central. Now, I'm now going to address attendees, and these are some housekeeping matters. You should have received the litigation manual and the cases. You should also have received the biography of the faculty and the uniform application for CLE credits. Okay? Now, you will not get credits for this segment unless you can prove you attended and sat through the 45 minutes. If you split and went off and did not attend the full sessions, you will not get this information I'm giving to you, which is the magic word. There's a code that you have to put into your attendance sheet, which is online. And the code for this first section is 01IG1. 01IG1. Okay? You have to put that in to verify or to authenticate the fact that you attended and sat through this session. At the end of each session, I will be giving you a code. Okay? Now, all of you should have a copy of the program, and the next professor who, the next faculty member who will be making a presentation, this would be at 1:30. We are now going to have a 15-minute break, and that break will oh no, it's going on 1 o'clock. So we'll have a 30-minute break, and we will be reconvening for the second session, dealing with the nuts and bolts of 1983 trial preparation. And this would be a session which will cover how you prepare a complaint, how you investigate the case, issues dealing with discovery, voir direing potential juries, and jury instructions. The cases that will be mentioned, some of them will be supplemented by Attorney Donald Temple. but there are in the manual from pages 21 to page 28 and pages 39 to 40. Okay, so we will see you back here at 1:30, and that is when we will deal with the nuts and bolts of litigation. Now, let me just say a couple of words here on this. We want to impart the particular skill set so that if you draft a complaint, you will be able to survive a motion to dismiss on the pleadings. So Donald Temple, who brings to this enterprise over 42 years of trial experience, he will be taking you through step by step in terms of all of these procedures where you, and he's taking you all the way up to not only surviving on the pleadings, but also surviving summary judgment motion, which means after all of the evidence is in, whether or not we have made out a sufficient case based upon providing admissible evidence to support our pleadings and to survive a motion for summary judgment. So he will discuss all of those issues, but that will start at 1:30, okay? And so come back. You will not get credit for Donald Temple's lecture unless you're able to put in the code. And I am not giving you the code before the end of his lecture. Okay, folks, so I'm sorry that I wasn't able to join you at the beginning because of technical problems. And while I'm accused many times of being a technocrat, I certainly was not able to overcome some of these technical problems that some of my younger colleagues like Nana was able to master. But here I am, and I will see you back at 1:30, starting and with me introducing my good friend and colleague, Donald Temple. Thank you. So we're on break until 1:30.
On time ourselves. Want to just do a little bit of housekeeping. Again, during the presentation by Brother Donald, Professor Temple, if you have any questions, please put them in the question and answer, which is at the bottom of your screen here on Zoom. If you have comments, you can place them there too, or you can put them in the chat. We want to make sure that this is as interactive as possible. Would love to hear people's voices, but the way that we have it set up, that makes it difficult. So we at least want to make sure that you're putting your questions and your comments in the chat. Really glad to have you here for those who might be just joining based upon the program that we're following. My name is Nana Jumphy, and I am the president of the National Conference of Black Lawyers, the legal arm of the Black Liberation Movement. And this is our law enforcement accountability program. We do this program throughout the year, giving the effort to making sure that we have folks, Black attorneys that are able to do these cases that involve the injury, the maiming, the killing of our people by the police and other law enforcement agencies. And we have a wonderful, wonderful, wonderful group of panelists who are sharing their knowledge. As I said, for those of you that joined us for Professor Joyner's piece, every time I hear these folks, I learned something new. And Brother Donald is no different. You're going to be in for a great treat. Donald M. Temple practices law in the District of Columbia and the Metropolitan Area Federal Courts. He received his BA from Howard University in 1975, his JD in 1978 from the University of Santa Clara, and his LLM from Georgetown Law Center in 1981, with a concentration in international and constitutional law. He also attended the René Cassin Human Rights Institute at the University of Strasbourg, France in 1977. Mr. Temple has practiced law since December 1978, when he began his legal career in the U.S. Department of Housing and Urban Development, Office of General Counsel. His practice is concentrated primarily in the District of Columbia and Maryland federal courts, DC state courts, and various administrative agencies, including civil trial and appellate litigation, administrative hearings, arbitrations, and mediations. His practice includes commercial and civil trial and, contract disputes and real estate transactions, whistleblower protection, foreclosures, labor disputes, reputational torts, conversion, Title VII, and 42 USC Section 1981, race discrimination, human rights violations, 1983 police cases, and other constitutional litigation. He successfully litigated against corporations and governments, including but not limited to the United States, the District of Columbia, Prince George's County, Eddie Bauer, American Eagle, Pension Fund, Grand Hyatt Hotel, and others. His professional accommodations and accolades are many and include the Metropolitan Washington Employment Lawyers Association's 2018 Lawyer of the Year, the 2019 National Bar Association Heman Marion Sweat Award, the National Bar Association's Gertrude Rush Award, and the Washington Bar Association's Ollie Mae Cooper Award. I pass it off to Donald Temple.
Hey, good afternoon. Thank you for an overly generous introduction. And I just want to say it's always a privilege to share information. When I look at my own time, it was in 1978 when I finished law school. In 1980, I was a member of NCBL here in DC, and 81, president of a growing chapter. And my admiration and respect for Lennox and Hope Stevens, the late Hope Stevens, is beyond words. So as a public servant and a beneficiary of that work, I hope to share some things with the audience today. I'm originally from Philadelphia, and as a young boy at 30th and Diamond, I saw a police officer bend a Black woman's arm behind her back as he held her across the front hood of an automobile. That memory is still very concretized and etched in my mind, and probably has, in part, along with the late Cecil B. Moore out of Philadelphia, informed the way that I try to practice law. I'm a small practitioner and not a full-time professor, but I run a law school preparation program called the Charles Hamilton Houston Law School Prep Institute. And that institute is now finished its 41st consecutive summer program. We have a 7-week program where we prepare students for law schools across the country. And my practice, while administrative in the beginning, I started working in the Congress between 80 and 90. My first 1983 case was in Philadelphia on Market Street at the federal courthouse against the Philadelphia Police Department. 1990, I went into practice, and since then, focused primarily on civil litigation, constitutional litigation, and quite a bit of it, including complete trials in the areas of 1981 and 1983 in the federal courts, and our jurisprudence. Our 1981 cases are in the forefront of both trial and appellate court rulings here in the District of Columbia. So I come to the table still as a student, and as somewhat of a warrior of sorts, a small-time warrior. To NCBL's credit, I think you should know this, one of our recent cases went to the Supreme Court of the United States, and you hear about it all the time, and you may not know that we actually litigated it, lost at the trial level, lost at the Court of Appeals level, and with a very large firm took the case to the United States Supreme Court. And that's Artist versus District of Columbia. The reason why it's important in the context of 1983 litigation, because in 1983 cases, we're litigating federal and state claims. Until Artists, the court might kick out your state claims and you have 30 days to preserve them. We argued that the statute of limitations was told in federal court during the pendency of federal claims, which is a literal read of the statute. And we were able to prevail at the United States Supreme Court. And to NCBL's credit, plaintiffs' attorneys across the country who have federal claims dismissed and the pending claims are then forwarded to state courts. The statute of limitation period doesn't count during the pendency of those claims. And those claims could be told for a year or 2 years. So you should know that NCBL's fingerprints are on a whole litany of cases throughout the country that benefit the plaintiffs. Now, I want to, for the most part, I would say that we're drenched in litigation blood. As much as we try cases, we also appeal cases. And we've had some formidable appeals, but they taught me many lessons. And we've been in a lot of situations. But for the next 30 to 40 minutes or so, I like to, it's not enough, anywhere near enough time, but I'd like to share with you some tips I think that are critical. Anytime you're talking about police litigation, you're talking about two basic hurdles. One is summary judgment, and I would say the other is inevitably and not insurmountably qualified immunity. You've heard an eloquent presentation before me, and you'll hear another eloquent presentation by Professor Freeman on the qualified immunity. But people talk about litigation as if it's something that's fleeting. Hey, I'm going to sue somebody here, sue somebody here. But nowadays, litigation is brutal. And I mean brutal. And police litigation is no less brutal. When we talk about summary judgment, though, we can not only anticipate summary judgment, but unlike most people will speak to you, depending on the development of a case, I think you should also not foreclose that the plaintiff also can file a summary judgment, depending on your record. Because I think that sometimes we see these cases and we are always on the defensive and overwhelmed, et cetera, but I think that there are situations where the plaintiff, can file a summary judgment motion. But to cut to the chase and to grasp this whole issue of 1983 and even this notion of qualified immunity in particular, you'll hear more about it, I'm certain, from Professor Freeman. But most recently, there were two decisions, recent decisions actually, this summer. And one was in Mississippi, and that was the Jameson case versus McClendon. It was an African-American United States District Court judge who wrote an encyclopedia-like comprehensive decision, and it was 72 pages. And it was a police stop there in search of a vehicle. He rendered a decision precluding a claim based on qualified immunity. The reason why I suggest that case is because it's a comprehensive history of qualified immunity, which I'm not going to visit here, except to say that if you're going to be doing police litigation, you need to have a second nature about what all the history is and the development of the law, and know its evolution, as you just heard. And you, these laws is 1981, passed in 1866 by the Congress, in 1983, and it's 1871. They have a particular history and context, which is significant and informative. The second case is the estate of Wayne Jones. That case, which was handled by a buddy of mine from Virginia, is a case that has a tremendous history, and that's a Fourth Circuit Court of Appeal, which rejected, contrary to Mississippi, it rejected qualified immunity on page 20. So if you go to the Jameson case and you start focusing on how this court was thinking. I disagree with the decision of the United States District Court judge in Mississippi. And I think the case is close enough to not bar that particular case, and others may disagree. But if you're interested in this litigation, you should read it, think about it, compare it, and go back further into the proceedings in the Estate of Wayne Jones case, because that was a protracted case and with a very difficult judge at the trial court level. Moving forward, can I sue a police officer? Should I sue a police officer? A lot of thought goes into that. I chaired the Civilian Complaint Review Board here in the District of Columbia between 1990 and 1993 under Marion Barry, and I saw both at the trial, private litigation level, and as the head of the Police Protection, Citizens Protection Agency, just tons of cases. And it's a maze out here. It's a challenge. But once we start getting into civil litigation, I think there's certain contexts and cultures that we need to embrace. People seldom realize that the civil litigation involves a multiple stage platform, if you would, that's continuous in nature. And that platform is the place where we actually litigate these cases, and there's a context and a culture associated with it. When you begin to practice law, you realize that there are dynamics, some that are written and some that are unwritten, that come into play as a strategy in the litigation process. But there are basic things that we need to understand in terms of that continuum. There's the pre-litigation stage. That's a space unto itself for cases of this nature. Then there's the pleading stage. That also is a dynamic unto itself. And obviously, and not always, a motion, a Rule 12 stage, which is generally Rule 12b-6, failure stated claim, and some other types of attacks that can come against the plaintiff. And then we move from that stage to one of the most significant stages in this litigation process, which is the discovery stage. And it's more than a notion. Discovery stage, we go into a summary judgment stage. Depending on the jurisdiction, we'll have ADR mediation. And surviving summary judgment, we go into the pretrial stage, which is a dynamic unto itself. And of course, the trial stage, and then the post-trial stage. I'm going to stop, and I'm only going to move in this limited amount of time through the pre-trial up to the point of the summary judgment, and that's Rule 56. And in order to really move into a flow of these cases, there's a body of rules that are constantly coming at you in this litigation, which is like a chess game. Keeping in mind the culture, the dynamic, it's a continuum. And keeping in mind that the other side is not going to say, you're suing me, here, we quit, white flag, you win. It doesn't work like that. And I've never seen it work like that. In fact, my whole litigation life is a theme. Catch me if you can. Catch me if you can. So there is a burden of proof, and there's a body of evidence that you need to meet your burden of proof. And then there are dynamics that come into play, such as qualified immunity at a certain stage. But before we get there, I wanted to talk about the pre-litigation stage and the kind of dynamics, and particularly for 1983 cases, the kind of information that we want to ascertain as we develop our pleading to give us the best possible judgment about the development of the case. And in that regard, I might anecdotally note that we've attached some documents that are readily available. And they're very practical documents, which include a civil complaint and in a wrongful death case that was litigated here in the District of Columbia, jury instructions in that case. As we think about these cases, and for pre-litigation purposes, if you're doing a 1983 police search, a wrongful search case, look at the jury instructions. Look at the jury instructions for a wrongful death case in your jurisdiction, so you know the parameters, where you're going, how the courts see the legal framework for the proof issues should you get to trial. we've attached a case on spoliation and what happens if people are hiding evidence. We just had a case turned on summary judgment, not a police case, a Title VII case, where the evidence was disposed of, and we would not have prevailed or may not have prevailed on the Title VII case, but for the spoliation against a federal agency, what got us past summary judgment and to a point where the case was settling. This is a great decision on that, and it's an arrow to have in your quiver, because sometimes documents end up missing, but not without consequence. We have a excessive force expert report, and that excessive force expert report is critical. And this is a good expert report. It's a comprehensive expert report. You have to have some understanding how these reports work. And this particular report, once you read it, it gives you good context as you start thinking about this litigation. We have the appeal, an appeal that we did on a 1983 case in the Fourth Circuit, where qualified immunity was denied, and the defendants appealed, and we prevailed on the Court of Appeals, where the court basically affirmed the lower court's denial of summary judgment. And that happened twice with us in the Fourth Circuit. And so there's a bit of helpful information, but let me go to the pre-stage, because conceptually, as you're thinking about a lawsuit, what kind of information do you need? There's a wrongful death, there's a beating, a shooting, an arrest, et cetera, et cetera. Where do you start? Well, generically, you have to have some idea of who you're challenging, because under Monell, your cases can be bifurcated. Those cases can be against the institution, i.e. the municipality, or against the individual or individuals, depending on the circumstances of the case. But knowing whatever those facts are relative to your litigation strategy, there are things that are critical that you need to know. Now, one of them would be what police regulations, what police orders, policies, procedures govern a particular action. Critical that you, and this information you can, in most instances, obtain before you even file a police lawsuit. So you have a context to what the police should have been doing under that particular circumstance. More often than not, that information can be also referenced in your pleading for definitiveness as you allege the wrongful behavior of the police department. The incident reports, and there are multiple incident reports depending on the jurisdiction, but most jurisdictions, anecdotally speaking, might have a use of force report. We just had a case where we filed and there was a use of force report requirement, but in the defendant's motion to dismiss, they denied certain information, et cetera, not mentioning the use of force report. We filed a counter document saying that the court couldn't rule on it without the use of force report. We hadn't been in discovery, and it may save the life of the case, but even having the knowledge of the different rules and policies and procedures and what's required. The training documents are also important. Sometimes you can get those training documents in government reports if you're aggressive enough. We have an electronic system now. The academy, what they teach, what they train. For example, on basic issues like probable cause, that information is oftentimes available. Who is the officer? When I chaired the police board, I noted that there were probably 25 officers that were really bad apples, and those officers are also being sued. Well, if you look at your jurisdiction or in terms of the lawsuits that have been filed against individuals or against the police department, there's an incredible amount of information regarding the policies and procedures of the department, and oftentimes that officer or that particular practice, for example, in areas such as discipline. To give you an idea of going to your constitutional burdens and particularly on the Monell side, the policies and practices regarding these different subjects, disciplinary action, training action, and the like. I've included a deposition transcript among my exhibits of a wrongful search case where we did a 30B6 deposition of lieutenant, in this particular case was very tricky, but we were able to get through some of the policies and procedures and to get him to explain those policies and procedures to a point that a critical issue was the signature on certain documents where the supervising officer was to review the underlying warrant to ensure its accuracy. And in this particular case, the policy said that it had to be a sign off. This witness testified that that was true, and that in this particular case, there was no sign off. Case is pending. But the fact of the matter is that that deposition transcript is there. It's informative. The next person that has a case of this nature can find the case, find the deposition transcript, looking under the rock, that's under the rock, that's under the rock, and then find the ammunition that will help them to develop their case and their theory in terms of their complaint. Eyewitnesses, of course, et cetera, et cetera. Start thinking about a couple of things preliminarily. Excuse me. A couple of things preliminarily in terms of once you throw the litigation punch, once you file the complaint, you have to be mindful of the demands on you. And there are a lot of timing demands. So the rules become critical. The federal rules, the local rule, and the judge's expectations. A lot of lawyers and small practices get jammed up because the rules are overwhelming and they're not versed in the rules. And so they miss them and misunderstand their application and strategically how they can be used as a sword and a tool. And a sword and a shield, excuse me. There's one other thing I would like to commend to younger lawyers' attention, and this is a fascinating rule, and this is pre-litigation, pre-filing a complaint. Federal Rule of Civil Procedure 27 actually allows you to take a deposition before you file a lawsuit. I've never seen it done. We've discussed it many times, and now I'm thinking that it might be a good test instrument to depose someone when you don't have enough information to file a lawsuit and you have any other way to get it. I commend it to your attention. Maybe someone among you might challenge it. Choice of venues for lawsuits. We're here in DC. If we have a case in DC or Maryland, we can go into state courts, federal courts, just like you. Oftentimes, we are in federal court. If we're suing the District of Columbia, footnote, we might sue the District of Columbia because we know they're going to move it to federal court. Filing in DC is $130. Federal court is $400. We save our client $270 by filing in DC. It's going to be moved to federal court, and that's that. But once we know that the complaint is filed, and there's a compendium, and there's federal and state claims in these cases, you understand that. And what's critical though, once we file, we know that we have to get it done. There's some nuances here I want to share with you about lawsuits and filing complaints over the years, because there's situations where, you have a statute of limitations, you're concerned whether you're going to meet the statute. Of course, it depends on your state laws, whether they're 1-2 year statutes, particularly your common law claims. That's not the case on your federal claims. But if you got to preserve your common law claims, even if you're filing a federal lawsuit, you got to get that lawsuit filed, right? Well, as a rule, file your daggone lawsuit. It may not be perfect. File your lawsuit to make sure you meet the statute of limitations. Okay, in an exaggerated context, you may have misspellings and typos in this paragraphs. The claims are there, basic facts are there. File it. Why? Because the federal rules are very generous in terms of allowing you to file and amend your lawsuit. They're very challenging and punitive if you don't make those deadlines. I've seen a case in Philadelphia where my buddy said his computer had broken down years and years ago, and the judge said, well, you should have handwrote it and filed it. File it because Rule 15 allows you to amend your lawsuit. Why is that significant strategically, folks? As a strategy, there are always dynamics in the earlier stages of litigation. And Rule 15 is a tool for you. You file a lawsuit and it's attacked by the local government vociferously on particular issues. A couple things happen. They flag you on the vulnerabilities of your lawsuit, points A, B, and C, whatever they might be. Under Rule 15, you have a bite at the apple, a second bite at the apple to amend your lawsuit. If a motion to dismiss is filed, you can amend your lawsuit up to 21 days after the motion is filed. So it's a very generous proposition. Or assuming no motion is filed and you file a lawsuit which is deficient or defective in either legal or factual context, then Rule 15 allows you to freely amend your lawsuit. Your client doesn't have a lot of money, you're in situation dynamics, you're trying to manage this issue and 30 other cases, you got a lot of pressure on you. You file the lawsuit. Rule 4 says that you don't have to serve the lawsuit for 90 days. You can file a lawsuit, make certain adjustments, and then day 45, day 60, serve the lawsuit. By the time, there's no rush to the courthouse necessarily once your claims are preserved. So you can file it and you can serve it, and then even then you can still amend the lawsuit. After an answer is filed, even after an answer is filed, you have 15 days to, 21 days to amend your complaint. So the rule is very generous, and the timing is critical in terms of the statute of limitations. Once you get past the filing of the lawsuit, the service of the lawsuit, et cetera, you are going to enter into assuming no motion to dismiss or you survive a motion to dismiss, you're going to enter into the world of discovery. And it all is very, very, very scientific and all very, very time sensitive in one respect. On the other hand, it's nuanced and dynamic and subjective in the other respect. I get a case, I want to know who the other lawyer is. Sometimes I've dealt with them, or I'll call somebody and say, yo, tell me about this person here. What's the deal? I want to know who the judge is. At all times, in terms of presentation of the judge, I've served the paperwork, et cetera, but I've not had any interaction with the judge until now. We're getting ready to get to that stage. And we had to also have in mind in our backpack, our litigation and discovery strategy. You have to have a strategy. It's a continuum. You're moving through this piece, and each phase is a dependent variable. You can lose out at certain things here, and it can hurt you down the road if you don't focus on what your objective is. In this particular situation, it's getting those facts that are critical to the elements of your respective claims. Particularly when we're speaking about the constitutional claims and the kinds of scrutiny that United States district courts are giving to these qualified immunity claims. So you're focusing on that, but let's talk about what that means in terms of the rules. And the first point of interaction with opposing counsel on this particular issue goes to your 16B obligations, Rule 16B, which is your scheduling order. People look at scheduling, oh, we're getting a scheduling order from a court, well, not so fast. You have your 26F meetings with counsel to discuss a proposed scheduling order with the court that's going to go to the court, the court's going to issue this order. Discovery becomes critical. And I would say to you, in that first interaction, there's a couple of things that you, or at least I like to establish with counsel. As intensive as this process is, I enjoy a reputation of being a very civil lawyer and a very sensitive lawyer with the judges. You know, I was on a court today with the court and I couldn't get evidence that I wanted, but I was also in the CLE last week where the judges were complaining that they don't want you filing all these motions. They want the lawyers to try to work it out. I established with the court every best effort to resolve a discovery issue, let the court know that we were still trying to do it, but that we're moving to a point, having already had a meeting conferred that we may have to file it, but at least the court knew, and the court knows and respects, and I underscore this, civility. Don't stoop to the other lawyer's level. To the extent that you can, just always be honest, forthright, and and it will give you tremendous, tremendous, tremendous rewards. So on the 26, F is critical. Keeping in mind a federal court under Federal Rules Civil Procedure 26D, litigation doesn't start until discovery order is issued, which is the Rule 16 statement from the court. But here's something that I noted, that in these federal courts, oftentimes when the court issues its order in the United States District Court for DC, the standard order for the district court discovery, civil discovery, has the Rule 26A2 expert notice within 60 days of the order. And most lawyers just right over their head. Well, if you have to have that expert report noticed and filed within that time period, there's implications for you, both substantively and sometimes financially. What I do, and I would suggest to you to be careful when you can resolve that problem when you have your 26F meetings with counsel, and you can say, hey, look, this is the way we see this thing. Why don't we push this back? And so our expert reports are not going to be due 60 days. Rather, our expert reports are going to be due 150 days, or we'll have a bifurcated discovery for the fact witnesses and then for the expert witnesses. And so you can work that out, but you have to be careful of those timelines. If you go across the street to the Eastern District of Virginia, those cases move like this, boom, 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 boom. And so where these different obligations come into play become very, 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 very critical for you. But that discovery plan and the timelines associated with their rule, they're 21 days, 14 days, et cetera, et cetera. But here's another piece, and I direct your attention to 26A1. Of course, you know that requires initial disclosure. That references initial disclosures, and each side is required to present their initial disclosures to the court within 21 days after it enters into its scheduling order. Well, the initial disclosure is another piece that's over our heads, but it's a critical stage of the litigation in terms of the discovery, because in the initial disclosure at 26A1A, each side has to disclose their respective witnesses. Now, as the plaintiffs in a police misconduct case, your witnesses are really a lot fewer as a rule than in the police department, where there are multiple witnesses and police officers in a particular situation. There may be supervisors who sign and review the incident reports, et cetera. They're authors of reports, they're reviewers of reports, et cetera. But the defendant is required to tell you who their prospective witnesses are in a particular case at the point of that 26A1 initial disclosure stage. 2, they have to tell you what documents, as do you, what documents each side has. So this is your first glance at the defendant strategy, knowing what you've already known or developed from your preliminary work before you even file your lawsuit, to see whether what they're giving you actually matches or is credible as to what you already know. And thirdly, 26A1C is damages. Rob here for the plaintiff's lawyer. The defendant's lawyers are sometimes going to come after you and say, well, in your initial disclosures, you didn't say what damages was. I had that with the city, District 1 recently. And I said, well, I don't know, except in that particular case, we did something at the beginning, which was critical to our case because we had an economic damage situation. So we hired an economic damage expert in the beginning, cost $2,500, $2,800, somewhere along that line, but I knew we needed that person. And so we had an expert report before we even started the case on the economic damages, which also was critical for us because we had some assessment, as did ultimately the other side, that we were being serious about the projection. But we had a document, and that document was, we were able to give that document to the other side at the initial disclosure stage. It also showed the other side that we were serious about the presentation of the case, and that there was financial value on the economic side. Then there's a question of medical damages, assuming there's not a wrongful death case. It could be a beating case, it could be something else akin under this rubric of 1983. And in the economic, keep in mind the medical, anecdotally, from a strategic point of view, is not only physical, it's also psychological and emotional. So I would urge and underscore that I really didn't understand in the beginning years of my practice significance of psychological, emotional harm to victims. And sometimes it's much greater than the physical harm. And an example of that I mentioned earlier, I'm still remembering an incident that didn't even happen to me at age 12 at 30th and Diamond Street with a woman's arm behind her back. What about her? What does she remember? And the level of imposition that it is. And so having a doctor opine on it, or even more so, getting your client to a psychological doctor, a psychologist, or a psychiatrist even, is of value. And that psychiatrist, by the way, under the federal rules, that psychiatrist or that medical doctor is deemed an expert. So when it comes time sensitivity speaking, for you filing your expert reports, you also have to identify the physicians as experts. And I've seen it more often than not in this jurisdiction where people say, well, I didn't know that. Well, that's the case. Not only is it the case in federal court in DC, it's the case in state courts now, and probably is a trend. So on the medical damages, medical bills, et cetera, you have something that's concrete. You have something in terms of economics. On compensatory damages, of course, we made this argument that you couldn't really predict what a jury might do in terms of compensatory damages, citing the local jury instruction on compensatory damages. So at this point, we also, and so at a very early stage, by the time you get your 16B order, your scheduling order, you have some idea of what the case dynamics look like, where you have to go. You're also mindful, for purposes of 1983, in terms of Monell liability, of the police organization structure. And you're sensitive to decision makers, policy makers. You're inquisitive about the training, the police academy, and the training that goes into the execution of warrants or the use of firearms. You're inquisitive about the reports, the use of force reports, and the extent to which they were filed, or governing compacts or dynamics within the department regarding certain operations, because there may have been historically problems in the department with shootings or beatings or false arrests. And so you're already there. So now you're getting into the actual discovery part of the case. In this respect, there are a couple of rules that also come into play. I mentioned the initial disclosures. The initial disclosures should be one file on your discovery strategy, because you're going to come back now with your interrogatories, request for production of documents, and your request for admissions. But you will find in this particular process that the defendants will not have given you, at the early stages of your initial disclosures, information that they didn't want you to know. Why? Because catch me if you can. Why should I can't tell them that we have this document. I can't tell them there was this witness. I mean, that's something that you have to have intuitively in the back of your strategical mind in assessing the litigation. Moving forward, though, is that in the discovery process, particularly under Rule 30 and 30B6 and Rule 37, there are things that we should be mindful of, just on the initial disclosures and your documents, et cetera. Remember that there's a timeline for responding to interrogatories and document requests. Be mindful of that, because you're going to be so overwhelmed. On the other side, the minute you slip, they're going to attack you, and the next thing they're going to tell the judge, this guy is not responding. Then you're on the defensive, et cetera, et cetera. So you had to be anticipating that this discovery is going to come in. Likewise, you're going to be following this. Don't wait till the scheduling order to file, or start thinking about you're going to file discovery or request for production documents. That can happen very easily based on your preliminary preparation, the development of your pleadings, to the point that you have your discovery, which can't be served until the court enters into its Rule 16 order. The date, and no later than the date that the court enters into its Rule 16 order, you should be following your discovery. Again, it will show the other side your level of preparation, your level of seriousness, and then they may be doing the same. So at least you're ahead of the game. And that happens when they hire big firms, et cetera, to represent the government, et cetera. No matter what, they know that you know the rules, and they know that you have some type of game plan that's going to move you closer to what you want to get because you know where you want to go. And I mentioned 30B6 depositions. Well, obviously, and we've attached a request for production of documents. There are many, many, many samples of those interrogatories and things like that. Critical to that process, though, is that don't get lost in the sauce, because you're going to always get documents as a rule. Catch me if you can. They're going to give you documents, but somewhere in those documents, either something is missing or something's not accurate or something. You got to pay attention to what you're getting systematically. Keeping in mind, you got initial disclosures over here that you have, and now you're starting to get answers to interrogatories. You're getting documents and you're getting objections. And if you're late, by the way, in submitting your request for production document responses, those objections are weighed. So you want to make sure you preserve your objections, and you got to begin to challenge these guys, particularly in areas of privilege and other areas where they're making objections that they're not producing documents, because you're not going to get, somebody's not going to just give you a rope to hang them with. So you have to be very focused in terms of the evidence that's coming into play. I'm sorry, I was trying to read the notes. So these documents that are coming into play, because they're going to be situations, and you can't give an inch, because you never know what's under the rock, that's under the rock, that's under the rock if you don't look under the first rock. But if you file motions to compel, where there are non-responses to interrogatories, or they're not sufficiently answered, or the documents are not given to you, it's critical. You can prepare. And I've given you a sample of a motion to compel in a Hunley case that was filed. You can prepare a motion to compel. You can have it ready. You can anticipate that the other side is not going to give you a motion to compel. And I tell you these things because once you get into the cases, they're overwhelming. There's so much there. But you can prepare, and I've given you things. I've learned this. I'm giving you the benefit of having been drenched in this blood. I'm giving you documents that you can look at. And you can actually alter them, but you can see the strategy so that when the motions to compel come in, when the situations arise, you're prepared to deal with that. The 30B6 depositions. The 30B6 depositions are critical. Strategically, at your Rule 26F point, you should be trying to schedule depositions. I was in court matter recently, and we did just that because it was a very contentious case. And I told the person I wanted to depose persons A and B, and they were defendants, father and son. And they said, well, we'll get you dates, we'll get you dates. The pandemic hit, we'll get you dates, we'll get you dates. We're still waiting for dates. And at the same time, you have the opportunity to do those people in this kind of case, the 30B6 witnesses are representatives on particular areas. Hey, police department A, we want to do a 30B6 deposition of a person on your training. Get me to the academy. I want to know how a person is trained on the use of force, probable cause, search warrants, et cetera, et cetera. Get me a person on disciplinary practices at 30B6. It could be the same person, mindfully, but you have that opportunity, but you can actually forecast, and this is sensitive. You can forecast out at your 26F meeting. Hey, listen, we got to have 120 days discovery, 150, 180. Listen, I want to do these depositions in the period of day 75 to day 90. Can you give me dates? I'm going to send you notices. I'm going to tell you what I want. I need to know if you're available, because then if you're telling them that and they say, versus you saying, I want to do a 30B6 deposition, and you say that to them 60 days out, how much time I got, Donna?
We started a little late, so I'm going to give you another 2 minutes.
Okay, then you have a way to get those depositions in advance. I'm going to close out then, Nana. It's not, I think that this takes us through some way of discovery, except I'll tell you this. Discovery answers and depositions are critical. Always be respectful, always be polite. Try to schedule your depositions as much as you can in advance, but here's a rub, and I see it a lot, speaking objections. And I've had fun with it, quite frankly. People think they're client doing talk, challenge speaking objections. Object, make a record, get the transcript or parts of it. If it's live, if you have an obstructionist attorney on the other side, with Zoom is great because you can video record these depositions. You can take the excerpts and then file a motion for sanctions against the other side for their speaking objections. Put them on the defensive. Last point on summary judgment. Professor Freeman will speak about this. Develop your case in a way that as well, it's not just about your constitutional claims, you also have pending state claims. But you can develop this case in a way that you can also file a motion for summary judgment on both the federal and state claims. To the extent that this is 40 minutes now, and I hope it's useful, I would just say that these rules are critical. Rule 8, Rule 4, Rule 8, Rule 11, Rule 12, 15A, 16A, 16B, 26A, 26A3, A, B, and C, 26F, 27, 30B, 37, 4M, and 56D. On the summary judgment, one last point just happened to us in federal court. 56D, if you're not ready and the record and the other side hasn't allowed you the opportunity to develop your record, you file Rule 56D affidavit and to explain to the court why the case is, the decision is premature. It's a good avenue and another instrument, another arrow in your quiver. Thank you. Sorry to talk so fast.
No problem. I want to talk fast, but it's my time because it's not a lot of time. But we really want to thank you for getting all of that in there. This is the portion of our LEAP training where we really get to get in it. You know, it's like we get to get in it with Donald. We get to put those gloves on and be there, and we feel ourselves there, especially those folks who are working on these cases right now. And the only reason I stopped you, and because we could have gone on for a little bit longer, is because there's so many questions that people have.
Okay,
and I want to make sure, especially because this is a sort of an intimate group, I want to give people the opportunity that they would not normally have if there was 30 of us, right, to ask these questions. So people are asking about the pleadings that you've described and the case sites. We do have a manual as well as a separate book that has this information, and we're going to check during the break to make sure that everyone has gotten both because they were sent this morning, East Coast time, really early this morning, my time, West Coast time, and so you should have that. Laura asks if there's any place to get experts in the police field, where you look for that. And also, she sued the city clerk and the HR person, the chief, all of these folks, the lieutenant and city and mayor and the city manager. And so she wants to understand, can she roll with that or what's up?
Why? Why do people think they got to sue everybody?
Because that's what they tell us to do, sue them all. So tell us what
I mean, if you're suing all these people, what kind of liability are you going to get? It depends on the nature of the case. And I don't know. If I'm a judge and I'm looking at you suing all these people, they're going to have all these lawyers, et cetera, et cetera. My Uncle Bernard told me when I was in the ninth grade, he said, no matter in life, Donald, whatever be your goal, keep your eye on the donut and not on the hole. And so I don't know that it's necessary, depending on the facts, to sue everybody. I would have a very targeted focus because you don't have that kind of resources and capacity. Most of us don't. You know, you got to complain with 50 people listed, then you got to serve them. You got to, I mean, so it depends on the case, but I'm not one to, now there are times where they were going to be model people. Don't get me wrong, but the clerk in property immunity, okay, absolute, depending, I don't know what a clerk could be doing. HR person, I don't know what an HR person could be doing. If I'm suing the officer and I'm suing the department, depending on whether or not I can meet the Monell requirement, I don't need to go suing his supervisor unless it's really a bad case, and that's rare. I want to be very focused. I have limited resources and I got to hit the target. So I'm not that guy. And I don't know that you want to be that person. In the courts are. You're always listening to the courts. Always, federal court judges get 600 cases a year. And so your case is 1 in 600. And so they're watching how you present your case. You know what I mean? Next
And those
question.
depositions are going to be a nightmare. The other part of that question was, any place, where do people go to get like police conduct experts, those experts that help us to talk about what the police should be doing, et cetera? Where do people go for that? And I got 4 more questions after that.
I mean, you go to people, I just gave you an expert report with an expert. Okay, that's, I'll get it from somebody, or I'll get an expert that I use. People who do 1983 litigation may know experts. They're rare and they're hard, but also you can kind of go to law schools and get experts on cases. The expert fees are preposterous. These experts are charging arms and legs. I mean, but they're there where they're expert companies, but those fees are exorbitant. But if you go to some of these people that are doing police cases, those experts there, sometimes they're affordable. I've given you the name of one and a sample expert report in my documents that I gave to Lennox.
Perfect. And then Savannah had asked about, if you know, remember off the top of your head, what the case was concerning the statute of limitations in the Federal Court of Claims that you mentioned in the beginning. Is that something they can find in the site?
Actually, it's a United States Supreme Court case. It wasn't a Federal Court of Claims. It was the United States Supreme Court ruling on a case called Artis versus District of Columbia. ARTIS versus District of Columbia, 2018.
So Laura has another question saying, she says that there's a state court filing just got over to federal based on a move to remand because only constitutional question right now is 1983. They filed for a motion for a more definite statement, and she says she always files more than simple pleadings because she's afraid of leaving something out. What do you think?
If they filed a motion for more definite statement, remember under Rule 15, she could amend her complaint. They had to spell out what's indefinite and why they think there's a vulnerability. So they're telling her what she could do. It's probably a formality rather than a legitimate motion if she's as detailed as she's suggesting. And to remand the case to of course they probably, I don't know what jurisdiction it is. They want to get it out of the federal court for some reason. It sounds like it may be some good underlying facts, but she should fight to get it in. And then just based upon what they're challenging in terms of the motion for a more definite statement, I don't know what that could be. I don't have anything in front of me, but she could probably amend it and tweak it and try to sustain, keep that case in federal court. Hopefully that would be a decent decision in that jurisdiction.
Thank you. Thank you so much. Those are the questions that we have. Let me check and see. I see that I may have another. Laura says, awesome, that really helped. And it seems like those are the questions that we have. Again, we're going to make sure that we get these materials to you because I know that we have those materials because I just use them.
And Nana, the only thing I would say too is read those 2 cases that Professor Freeman is going to talk about, but also eat the rules, the local rules, the judges' preferences, so you know the rules and the timelines. And strategically, you'll develop a knack for how to use them. Thank you so much for the opportunity to share this information.
Thank you so very much. That was fabulous, as we expected that it would be. We are going to now take our break. It's a 15-minute break, so it's from 2:30 now, 2:30, yes, y'all's time, to 2:45. And at 2:45, we're going to start with Professor Bernard Freeman. He's going to be talking about overcoming qualified immunity and other challenges in 1983 litigation. Again, it's going to be fabulous. You're going to be so glad that you got this opportunity. Treat yourself. Don't cheat yourself. Come back and make sure that you connect up with us and let others know, hey, it's not too late. Get registered for this thing. We still got 2 more sections to go. Thank you so very much. And thank you so much, Donald, for all that you've shared with us. Thank you.
Thank you.
Please remember to put yourself on mute for the break. Greetings. You're on mute.
Okay.
Greetings. So we're
Where
doing
are-
we're on a break right now.
Oh, okay. 'Cause I thought maybe you and I were in the waiting room.
No, we're on a break right now. Lennox has had some issues getting in, so I have become the on-the-spot moderator. So we're on the break right now.
Oh, boy. Okay.
Donald just ended. I'm only reading part of your bio. Don't be offended. But I went over Donald and I went way too long because I'm reading every word. So don't be offended by that, please. And
No, don't worry.
people are rearing to go. They've asked really good questions. People are engaged. So
Oh, good.
we're off now. I know that you're coming from class, so take a breather.
Right.
We start at 45 after. And
Right.
so, if you could just come on maybe at the 40 mark, just so that we can make sure that everything's working, everything's on, etc., and we can start on time, that would be fabulous.
Yeah, I'll just stay on now if you want me to.
That's fine. Just mute yourself because you never know what you might say.
Okay. True.
All
True.
right. Okay. Thank you.
Nana, check your chat for me.
Yep, I just did. Yes, and Yvonne, I know you can hear me. There's nothing I can do about that. Thank you. Okay, folks, we are back. We're back. We're back. Just want to let people know, because we have to give you our special code for our second segment that was given by our brother Donald Temple. Our second code is 0DT2. 0D T, like Tonda Sizwe, 2. 0DT2. You need to have that code if you want to get MCLE credit. 0DT2. So hopefully people are back now and ready to begin our next segment. We are so pleased to have joining us Professor Bernard Freeman. Professor Bernard Freeman is Professor of Law Emeritus at Seton Hall Law School. He's also an adjunct professor of law at NYU School of Law. He currently teaches Islamic jurisprudence at NYU. He's a member of the New Jersey Bar, having been admitted to practice in the Supreme Court of New Jersey in 1974, also admitted to practice before the U.S. District Court for the District of New Jersey, the U.S. Court of Appeals for the Third Circuit, and the Supreme Court of the United States. Professor Freeman was the founding director of Seton Hall Law School's Center for Social Justice. He served for 5 years as the board chairperson of the Essex Newark Legal Services Corporation. While director at the Center for Social Justice, he participated in litigation in the state and federal courts, raising issues under the U.S. and state constitutions for prisoners, criminal defendants, students, free speech advocates, civil rights plaintiffs, and others with significant constitutional claims. He's a longtime member of the Board of Editors of the New Jersey Law Journal, and he served as an elected member of the Board of Trustees of the American Civil Liberties Union of New Jersey from 1998 until 2008. He was a Samuel L. Goldlieb Fellow in Legal History at New York University School of Law, and is currently affiliated faculty member at George Mason University in Virginia. Professor Freeman got his BA from Wesleyan University and his JD from Rutgers University School of Law. He also possesses an LLM and a JSD degrees from Columbia University School of Law. Thank you so very much, Professor Freeman, for joining us today. You're on mute, brother.
Thank you very much, Miss Gianfi. I hope I pronounced that correctly. And it's a pleasure and an honor to be here. And I trust that the same will be true for your participants when I am done. My assignment today is from our esteemed organizer, was to talk about qualified immunity, and then 3 other related topics. These are in the manual, beginning at about page 28, running to about page 36. And the 3 other lesser topics are the res judicata and collateral estoppel, as well as the statute of limitations and notice problems and other smaller things. I'm going to spend about half an hour of my talk, maybe 35 minutes, on qualified immunity, which is the big topic of the day. And then the last 10 minutes or so, I'll talk about those other topics, and then we'll take 15 minutes for questions at the end. I see I already have one question from my classmate, Patricia Darden. I haven't had a chance to read the question. It's a long question, but I'll do that just before we take the other Q&A. So qualified immunity. Now, this has emerged as the most significant and most problematic issue in police misconduct in recent years, and it deserves probably perhaps a whole CLE session on qualified immunity. I can only give it about 30 minutes, but I'll do my best to give you a good overview of it, and then perhaps some practical pointers on how to deal with it if you are representing a plaintiff who's been the victim of police misconduct. The reason it's a really hot issue nowadays in litigation, there are a number of reasons for that. One is that it's never really been clear what the rationale is for qualified immunity. It's described as a defense, but the courts don't really see it as a defense, although it has to be raised in the pleadings by the defendant. If the police officer doesn't raise the so-called defense, it is waived, it's waivable, but it's really not a defense. It's more a claim of immunity, akin to other kinds of claims of immunity, where the defendant says, well, I might be guilty, but I'm not liable to pay damages for various reasons. And the rationale for that has never really been clear. And so sometimes judges are not really, don't have a good understanding of it. And plaintiffs' lawyers oftentimes don't have a good understanding of it. But meanwhile, police officers, from the time that they join the force and are out on the street, and when they talk to their union lawyers and also talk to private counsel, qualified immunity comes up. They are very much aware of the fact that it exists and that they can use it to protect themselves. A second problem with qualified immunity is that it uses empirical data oftentimes. The motions made by police officers and courts in deciding the question oftentimes look at empirical facts, and it's oftentimes a misuse of empirical facts in dealing with the defense. And so over the years, it's been enlarged. David Rudofsky, who's a very accomplished law professor and police misconduct lawyer in Philadelphia, has said that the courts have enlarged the immunity by stealth rather than directly. We've looked around and suddenly we see that the immunity is much larger than it was when it originally began. It started out as a simple defense raised by a police officer when he can assert that he or she has a subjective belief that what he or she did was lawful or not unconstitutional, and that he or she acted in good faith. It was first recognized in a case called Pearson versus Ray in the Supreme Court, which is the citation for that is 386 U.S. 547. I don't have the date, but it was in the 60s. Pearson v. Ray involved 15 religious people who sought to desegregate a bus terminal in the South, and they were arrested by the police. The courts, I think it was Alabama, threw out the arrests, and so then the clergymen sued the police officers for damages for unlawful arrest, and in using Section 1983, which is what this CLE is about. And the Supreme Court held that Section 1983 incorporates the so-called common law tort immunity for government officials who act in good faith and with probable cause in making an arrest. Actually, qualified immunity applies to more than just police officers. It applies also to school officials, to municipal agents, building inspectors, all kinds of municipal government officials who have some discretion, who act with discretion. Anytime a government official acts with discretion, he or she is eligible to use qualified immunity. I'm having a little trouble with my notes here, so I'm going to move them over where I can see them. So if you see me looking down, it's just because I'm looking at my notes. And so even though Pearson v. Ray, there's a common law immunity and it wasn't a big deal, if you act in good faith and you have probable cause or you had a reasonable belief that what you were doing was appropriate, and you don't act in bad faith, and that's a subjective belief, then you were entitled to the defense and you don't have to pay damages. The Supreme Court expanded the good faith belief in the lawfulness of that kind of action to eventually establish an objectively reasonable standard. That's a case called Wood versus Strickland, whereas if the defendant had an objectively reasonable belief that what he or she was doing was lawful, then they would escape liability. In the cases, the defendant has the burden of pleading and proving at trial that they're entitled to assert the qualified immunity defense. So the way it developed after Wood v. Strickland was kind of a different test than what was originally announced in Pearson v. Ray. He had to prove that the right was not clearly established. The right that was violated was not clearly established at the time, and that there was no malicious intent. Then there was a seminal case which came down, I think, in 1987, which is mentioned in your manual, and it is still the leading case on qualified immunity. It's a case called Harlow versus Fitzgerald, which actually did not involve police officers. It involved the dismissal of an Air Force employee by at the behest of presidential aides, people who were acting on behalf of the President of the United States. And in Harlow, the Supreme Court held that government officials performing discretionary functions generally are shielded from civil damages insofar as the conduct does not violate clearly established statutory or constitutional law, and a reasonable person, even if it did violate, it's a two-pronged test, even if it did violate some clearly established statutory or constitutional law, the defendant would escape if no reasonable defendant in that position would know that their actions were in violation of that standard. So Harlow established a situation where even where someone does not act with probable cause, or even where someone does act using excessive force, if a reasonable government official or police officer in our case in that circumstance would not have known about that standard, then the court says that they're entitled to the claim of immunity. Now, what Harlow also did, and this is very important, is that it moved the qualified immunity question from the summary judgment stage after discovery, or sometimes even after jury verdict, qualified immunity might be raised. It moved the inquiry to the outside, to the outset of the case. So defendants would make a motion, a qualified immunity motion, usually in two stages, either at the outset of the case on a so-called 12b6 motion to dismiss, based on the facts pleaded by the plaintiff, giving the plaintiff the benefit of the doubt on those facts, or accepting those facts to be true. Or sometimes it was done at the summary judgment stage. But after Harlow, defendants began to move to exonerate themselves by qualified immunity before even discovery was done, usually on the pleadings or on a limited factual inquiry. So if the law was not clearly established, the defendant's entitled to dismissal. If the constitutional statutory law giving that defendant the prohibition on doing what they did, if that law cannot be, it was said to be not clearly established, then the defendant's entitled to dismissal. Or if he could not have known that his conduct was unlawful, then the defendant's entitled to a dismissal. And so it became, after Harlow, a threshold inquiry in police misconduct litigation rather than at the end of the case. And so because of that, prior precedent in the case becomes, in that kind of case, becomes very important. And this affects pleading and how you draft your complaint and your investigation and all the kinds of things that you do to work up the police misconduct case. The qualified immunity defense actually colors how one should approach that. Then there was another case, and this was a 1987 case. I think Harlow might have been 1982, which was also extremely important. It was a case called Anderson versus Creighton, which is cited in your manual. That's at 483 U.S. 635, decided in 1987, and an opinion by Justice Scalia, which held that had to do with a search. I think in Anderson, it was a case against the FBI because qualified immunity also applies in Bivens actions when you file an action against a federal officer. These federal officers in the Anderson case were looking for a fugitive, and they claimed that the fugitive was in this third party's house, and they, without a warrant, without necessarily a probable cause to believe that the fugitive was there, they unlawfully invaded the third party's house, and that third party brought an action against the officers, and the Supreme Court applied the qualified immunity defense, and Scalia held that whether a reasonable officer could have believed the warrantless search was lawful, it was the question, not whether or not the warrantless search was in fact lawful, but whether a reasonable officer could have believed it to be lawful. And so the focus after Anderson then shifted to the precise conduct of the officers in the circumstances. And so prior precedent, again, was even more important after Anderson was decided. And now in the circuits, in almost all the circuits, the district court is, by virtue of Anderson, required to look to the precedent in the circuit, and unless that precedent is effectively on all fours with the action of the officers, unless it's just like, almost just like the officer's action in the circumstance, then the officer, if it's not just like what the officer tried to do, then the officer is entitled to a dismissal. It's not simply that the rule announced by the court was that a reasonable officer would have known that his precise conduct was unlawful. It's not just that the precise conduct, I'm repeating myself a little bit, that the precise conduct was unlawful, but that a reasonable officer would have known that his conduct violated the law. Stevens, Justice Stevens, in dissent in that decision, although the case was about FBI officers, he sort of presciently announced in his dissent that the decision stunningly restricts the constitutional accountability of the police, and that has come to be true. Even constitutionally unreasonable conduct can be objectively reasonable for qualified immunity purposes. Even though a court says, well, what you did was unconstitutional in this circumstance, it still could be said to be objectively reasonable if the officers in the circumstance would not have known. It's a really, that case, the Anderson case, was also a big blow to plaintiffs. So what does this mean when someone is drafting a complaint in police misconduct circumstance? It means you've got to search the circuit decisions and Supreme Court decisions to see if you can line up an analogy to the conduct that your officers are alleged to have done, and whether that circumstance fits that analogy. And then also, it means inquiry into training, into policies of the municipality, into prior circumstances that the police officer might encounter, to draft in the complaint, anticipating the qualified immunity defense, anticipating that facts which would enable you to defeat the defense in advance. What the courts have said is that this standard, requiring a clearly established constitutional or statutory right, therefore requires a high degree of factual particularity for the plaintiff to survive a motion based on this circumstance. One of the most horrific decisions applying the qualified immunity defense, again, was not a police case, but some of you who are old enough might remember it. There was an action brought by Padilla, who was alleged to be an Al-Qaeda conspirator, against John Yoo, who at that time was a assistant attorney general in the Justice Department. He's now a law professor in California. And Padilla alleged that John Yoo, who approved basically actions that amounted to torture of Mr. Padilla when he was held in custody by the US, who personally approved those actions. So Padilla brought an action for damages against Mr. Yoo, and a court of appeals exonerated Mr. Yoo, because even though it was alleged that, yes, what Padilla went through was torture, you did not know that subjecting someone to difficult sitting and laying positions, cold, loud music, electric shock, all the other kinds of things that we recognize as torture, because there had been no case that established that those things were torture, you was entitled to qualified immunity. That case, Padilla versus you could find at 678 Fed 3rd 748, decided in 2012 by the Ninth Circuit, which is generally a liberal court, and it's still cited by many police officers and others today, that it's got to be advancing the position that it's the precedent has got to be almost on all fours with this conduct that's involved in your case in order to escape qualified immunity. So this is a very bad policy in terms of plaintiffs in these circumstances. You've got to really canvass the precedent in drafting your complaint. Now, it's not as, it could be worse, actually, because there are some principles that are so axiomatic that the courts say you don't need precedent in order to say that the defendant was on fair notice that what he or she did was unconstitutional. The leading case, there are two cases. One's called Lanier. I don't have the citation, is L-A-N-I-E-R. But another one where I do have the citation is Hope versus Peltzer, which is at 536 U.S. 730, decided in 2002. And if the law is so clear and axiomatic that it would put any police officer on notice that what he or she does is unconstitutional, then you don't need a specific decision to do that. But that's kind of a narrow subset of circumstances. For example, causing someone to vomit, causing someone to upchuck drugs, or forcing that kind of thing, and other kinds of behavior, perhaps electric shock, using electric shocks and other kinds of things like that are clearly beyond the pale in terms of the Constitution. Now, there's a sort of a line of cases that have developed out of that idea of fair notice, where you have certain circumstances where you have a factually novel circumstance, some kind of circumstance that's never happened before and is unusual. This oftentimes comes up in prison cases. Then the courts will relax the factual particularity standard and apply the so-called fair notice rule. The plaintiff has to show in those kinds of cases that factual distinctions in the prior cases are immaterial because of the wide sweep of the axiomatic rule in terms of constitutionality. Now, most specifically, in our concern is going to be with Fourth Amendment cases, force cases, excessive force, which are viewed as Fourth Amendment violations. The use of excessive force is a Fourth Amendment violation. The cases still require a high specificity of facts, and also you can only, the qualified immunity defense is based on what the police officer knew at the time of the events. This is particularly important in excessive force cases, like the fellow in Michigan who's shot in the back when he goes in the car and his children are in the car, and there's a gun in the car, or a knife, I think it was. Well, the question is whether the officer knew there was a knife in the car. You decide the qualified immunity facts based on what the officer knows and not what later comes out in the investigation. Leading case on that is Fernandez versus Mesa, which is at 137 Supreme Court, 2003, decided in 2017, which involved a shooting by a Border Patrol officer of a immigrant who was trying to come into the U.S. And there's a question in the case, in the law, as to whether a non-U.S. citizen is entitled to the same Fourth Amendment protections as other people at the border. And so this officer shot this immigrant, not knowing whether he was a U.S. citizen or not. And the court reversed the Fifth Circuit, which applied the qualified immunity defense. The court reversed the Fifth Circuit, holding that if he had no knowledge of the person's citizenship, then it cannot be considered in the qualified immunity inquiry. And so even in spite of those cases involving those circumstances that I talked about, it is really clear that there's an increasingly higher demand for specific precedent in the circuits. So this also makes it important to look at the role of departmental policy and training. All these kinds of things can help beat the qualified immunity defense. Did the officer get circulars, memos, in-service training, instruction in the initial training that would deal with the situation that he encountered on the where you're involved? And if that's true, that you can establish that, then that will defeat it. You don't necessarily have to find a clearly established law from precedent. The clearly established law can be found from other sources other than precedent as well. Remember that the qualified immunity defense is not available generally to municipalities. And there's certain kinds of circumstances, going back to this axiomatic point, where the point about axiomatic rules, where qualified immunity doesn't apply. One is racial discrimination. If there is evidence in the case that the officer was motivated by racial animus, then the qualified immunity defense is not available, because it's everybody knows that racial animus is not permissible in the enforcement of the law. The third leading case, I've talked about three cases, Fitzgerald, and then the second case had to do with the name of it was just a second. Harlow versus Fitzgerald and Anderson versus Creighton, the second case. The third important case for you to take away from this, and I think it's in the manual, is Graham versus O'Connor, which is at 490 US 386. And that case establishes that the objectiveness of the qualified immunity defense, and the majority makes a really important statement in that case. Evil intentions will not make a Fourth Amendment violation where there's a reasonable use of force, objectively reasonable use of force. The fact that the officer has bad motives will not make it a constitutional violation. By the same token, good intentions will not save a objectively unreasonable use of force where the officer or reasonable officer in circumstances should have known about the defense. Now, let me just talk for a few seconds, and about the few seconds I have about 13 minutes, about the other more minor areas, and this I have some experience with in litigation as well. The first one is res judicata and a related doctrine of collateral estoppel. Many people think that a 1983 action has some sort of special status in litigation, and it actually does not. The 1983 action does not confer any additional rights on the, or it doesn't advance claims for rights that don't otherwise exist in our legal system. So a 1983 action really is just, most importantly, should be looked at as a constitutional or federal statutory claim based on tort, coming out of a tortious behavior. And so therefore, all of the rules that govern civil actions in the federal court would apply by the same token to a 1983 action. And so the most often where this comes up is where you have either a parallel action in the state court, where you might file an action under the State Tort Claims Act or under the State Civil Rights Act, and there's a decision against the plaintiff on that circumstance, that will bar a 1983 action with respect to if it's the same parties. All of the tests that apply with respect to applying res judicata apply in that circumstance as well. Most commonly, though, we see in 1983 actions application by the defendants of the doctrine of collateral estoppel. So the most common circumstance is where the question of probable cause for arrest comes up in the state court in a criminal prosecution, and the defendant concedes probable cause for purposes of dealing with a criminal charge, and then ultimately gets acquitted or gets the criminal charge dismissed, and then brings a 1983 action. It's bad news for the plaintiff in that circumstance, however, because the concession of probable cause, he will be collaterally estopped generally from raising the question of probable cause, or oftentimes a question in resisting arrest cases. He's where he wants to charge the officer with using excessive force, but he's charged in state court with resisting arrest, and he pleads guilty to some lesser included, or perhaps even pleads guilty to resisting arrest. That would be a bar to the prosecution of an excessive force case under Section 1983 under collateral estoppel. There's a very important case called Heck v. Humphrey as well. I don't have the citation, which also establishes that if there is a conviction or otherwise a unfavorable result on the person's state court criminal, usually criminal action, then that is a bar to later bringing a 1983 action on the basis of that same conduct. And Heck v. Humphrey, it's called the Heck bar. The Heck v. Humphrey requires the plaintiff in that circumstance to set aside or vacate or otherwise nullify the state court criminal conviction before the 1983 action can be brought. So it's important to very much pay attention to any kind of state criminal action, or sometimes it can come up in administrative actions involved in so internal affairs, or involving it with employment, where there's an administrative hearing that the plaintiff has to participate in and concede some facts in the administrative hearing without understanding that that concession will later be used against him in a 1983 action. So that is also an important thing to remember. And then also in your manual, toward the end of this section between pages 28 and 36, you have a little note on statutes of limitations. This tricks up lawyers. Most lawyers, if they do the research, will be aware of it, but some don't do the research and just assume that there's a federal statute of limitations that's going to apply in a 1983 action. That is not true. There is no statute of limitations for 1983 actions. You analogize the statute of limitation, and there's usually precedent on it in the state or in the federal court in that state on the circumstance. So it's if it's a New York action, oftentimes it's 3 years, New Jersey, 2 years, in terms of the usual kind of police tort, where the court will apply the analogous statute of limitations to that kind of action in the federal court. For example, in New Jersey, the statute of limitations for malicious prosecution is long, it's 6 years. So if your 1983 action sounds in malicious prosecution, then you have a long statute of limitations. If, on the other hand, if it's excessive force, generally in those cases, it's a short statute of limitations, and the 1983 action will be bound by that analogous state statute of limitations. One other related topic is the issue of notice. No notice of claim is required in a 1983 action. Some people think that you have to file a notice of claim like you do with most state tort cases. The answer is that that is not so. There's no requirement, and it's said to be under the supremacy clause to be, I think there's a Supreme case on this, to be actually unconstitutional for anyone to apply, other than Congress, which Congress has not done, apply a state notice of claim requirement to a 1983 action. On the other hand, there oftentimes are pendant or tandem state tort claim actions that are brought. And so the fact that a person also has a 1983 claim will not relieve them of the obligation of satisfying the state tort law with respect to notice of claim. Oftentimes it's 90 days to put the state on notice that it's going to be sued for tort. And the fact that there's also a 1983 claim does not change that requirement. So they're like apples and oranges with respect to state notices of claim, and you have to keep them separate, and sometimes they are handled separately. Now, states also have limitations on damages. Certain forms of conduct are said to be immune from damages, and there's an interesting question as to whether that kind of immunity would also apply in Section 1983 actions, and the general rule is no, that the damages in a 1983 action are analogous oftentimes to tort damages, and so therefore pain and suffering, and I think that the statute is pretty clear on this, pain and suffering, restitution, and the other kinds of damages that normally would be available to a tort plaintiff in a common law tort action are available to a 1983 plaintiff in the same way, in spite of the fact that the state may say, well, we don't have it in the budget, or we didn't legislate for this, or we have forms of immunity that we still assert, for example, in terms of dangerous instrumentality or other kinds of situations where the state wants to limit those immunities, limit those damages. Those limitations generally do not apply in 1983 for the same reasons as with the notice of claim requirement, that it would be a violation of the supremacy clause for a state to try to limit those damages. The analogy for 1983 is to the common law tort action. And so absent some statutory or Supreme Court or circuit decision to the contrary, when one does not know what the result would be, we analogize it to the common law tort circumstance. So that's pretty much what I have to say about qualified immunity and these other more minor things. I would remind everyone that there are 3 cases to do qualified immunity. You've got to know the 3 cases that I've talked about: Harlow versus Fitzgerald, Anderson versus Creighton, and the last one, most recent one, is Graham. Not most recent, but the one that's really important is Graham versus O'Connor. Anyone who wants to get ready to meet a qualified immunity defense has to master and understand the application of those cases, and then also run those cases in your research in your circuit, because the circuits do vary with respect to certain kinds of behaviors in the particular circuit. There's a recent case in the Third Circuit, for example, where a fellow looks like he's going to commit suicide, and he points the gun at himself. The state police officer shot him dead, even though he looks like he's going to kill himself. But that state police officer escaped on qualified immunity grounds because there was no case dealing with how to deal with a suicidal arrestee. And because there was no case, the Third Circuit found that shooting the suicidal arrestee was objectively reasonable, that he didn't know what to do. And as O'Connor says, I think it's the Graham versus Connor says, the idea of qualified immunity is to protect officers who have to make split-second decisions, so-called split-second decisions. So in that case, if it had to be tried all over again, I would advise the plaintiff's lawyer to look to training policies by the state police, New Jersey State Police. What were they told on how to handle suicidal arrestees and people like that? Because the general rule is you don't shoot someone who's trying to commit suicide. Thank you very much.
Thank you so very much. That was, again, fabulous. I keep learning. Like every time I hear the panelists that we have today talk, I keep learning. And our faculty includes other folks like Judge Geraldine Hinds and others who, can provide and are providing so much information that we need. I am going to start with the question from your classmate, I believe, Patricia, who asks, I am hopeful that at some point in the future, or maybe Bernard can discuss the role of police unions and how our cities, particularly when they get minority leadership, are challenged when we are co-defendants in these lawsuits. And then she goes on to talk about being a city attorney for the first Black mayor of Camden was an honor, but also horrific. Our union was so corrupt and racist. And she had issues with settling some cases because officers would expect that the city would write a check when they escaped punitive damages or any personal liability?
Yeah, that's a comprehensive question, and there's a lot of moving parts in that question. One thing that the question raises that I didn't talk about that's important is indemnity. In addition to qualified immunity, police officers, because of their union membership and the collective bargaining agreement, and then sometimes even by state statute, they are indemnified by the municipality or the state government. And so the indemnity issue also encourages violence. If the officer knows that he's going to be indemnified by his employer. And so I'm not sure of how indemnity is handled in 1983 actions. I think you've got to go to judgment and get the judgment for damages and then deal with the indemnity question. Also, an indemnity clause in an employment contract or in a collective bargaining agreement generally only covers certain kinds of actions. And so it might be a good idea for the plaintiff's lawyer to get a hold of that agreement to see, it might be, if you're lucky, that a civil rights action is excluded from indemnification. Or sometimes willful misconduct is not indemnified. And so you want to draft your pleading. I'm not sure how you want to do that. You might want to get indemnity to get the officer indemnified so you can get paid. If the officer, only has like a, third floor walk-up apartment and, and $43 in the bank, then it may not be a good idea to get out from under indemnity. But in other cases, you want to get around it. And usually there's no indemnity for punitive damages. I'm glad Patricia raised that. Punitive damages are available under Section 1983, but has to be egregious, willful, malicious conduct, and oftentimes that's hard to prove.
Absolutely. Thank you so much for that. Thank you, Patricia, for the question, and thank you, Bernard, for the response. Trying to see if we have any other questions. We do have lots of notes about how excellent the presentation is, as we did with Donald Temple and as we did with Irving. So excited about that people are feeling like they're really learning something here with the information that we are providing. I want to take this time to let folks know that your code, remember you need a code in order to prove that you've listened intently. I can see it, I see it here, right? Right here on the Zoom, but the various bar associations want something other than the word of Nana Jumphy. So you need the code, and the code is 0BF3. 0BF3. Again, that's 0BF3. That's the code you need if you want to get CLE credit for this session, this excellent session that we just had with Professor Freeman. Trying to see if we have any other questions. I don't see any other questions at this time. I'm sure people are still trying to digest in their brain all of the information that was provided for them, really practical information. And we really, really appreciate you and what you brought to this soup. That is going to be certainly tasty. We now have another break. Our next presenter is me, and we will be starting at 4 o'clock, my time. No, your time, 4 o'clock. So we're taking a break now. We come back at 4 o'clock. Again, if people have questions, let us know. Oh, I did want to ask you, Professor Freeman, and I forgot to ask Donald. So Donald, if you could put it in the chat, that would be great too. But if you could say out loud how people can reach you, and then we'll also make sure that that gets into the chat if they have any other questions or want to follow up.
Yeah, they can reach me at my email, Bernard.Freeman, that's Freamon, at Seton Hall University, SHU. That's a Sam Harry Uganda .edu, shu.edu. And I respond to those emails. That's my regular Seton Hall email. I also have an alternative email that's strictly private, which is b.freeman, Freamon, at yahoo.com.
Ooh, we got the secret one. See what happens when you come to the LEAP program? You get the special emails. So thank you again so very much, Professor Freeman. And
right.
we will have folks come back at 4 o'clock. Folks, we're back at 4 o'clock Eastern time, 1 p.m. West Coast time. Thank you so much. Don't forget to put yourself on mute. Let me know in the chat if you are back. I don't want to start too much in front of folks, so let me know if you're back. Put something in the chat just saying, hey, I'm back, so that we know that's the case. We're almost done. All right, Laura is here. Okay, Desiree is back. Back on Black. Excellent. Who else is back? Give folks a minute to be able to get back. That's right, Desiree. You stay on Black always. Yvonne, good to see you. Thank you for coming back. Who's back? Demetria, thank you. All right. So we're going to go into this last segment, and it's an important segment. What you've heard up until now has been the critical pieces of how we put these cases together, how we put these complaints together, things that we should be thinking about, immunities that we should be concerned about. Hey, Marlene, and so we've been all up in the books and the documents and the computers and the courtrooms, right? And of course, we can't talk about this without talking about the people, the human beings that we have to deal with and that we want to deal with as we're doing these cases. And so my section is going to be about that, looking at how we deal with, how we communicate with community, how we communicate with the person that's injured or their loved ones, how we communicate with activists and organizers, how we make decisions with them, document with them, and put ourselves into a place where we have a much better understanding of how to move forward on the case. So wanting to make sure, first of all, that people can see the chat, and I'm assuming that I'm going to get some word if that's not possible. But what we're looking at today is communities, families, and clients, and thinking about this with a movement-centered approach, right? So we know that it's critical that our work to hold law enforcement accountable for its violence and harm to our people must fit within a movement praxis. And our way of litigating police accountability cases should prioritize the needs of our clients and our communities while also challenging the core of the systems and institutions that protect and support the enforcers of the criminal sanctions system. And so when we are looking at our LEAP litigation praxis, it also serves as a critical political education and organizing tool that links our efforts towards justice for victims as well as communities with our anti-police terror activism and organizing of the streets and of the meeting halls and with our courtroom activism as movement attorneys. our ability to navigate that sometimes conflicting interest between our clients, their families, the community, and activist organizers as we are trying to litigate law enforcement accountability cases is essential to achieving the holistic goals of this litigation. So there's three main considerations that we, have to look at. One is communication, right? Communicating with the person, if they're living, their next of kin, if they're not, right, their loved ones, communicating with family. That could also just be the squad. It's not necessarily have to just be blood family, and documenting and making sure that we're getting things documented. So our primary obligation under the law is with our client. And for any of you who have done these cases, it's often difficult to try to get everyone to be clear about that, right? That our primary obligation is with our client, who is the person who has been injured or who has been killed by law enforcement. And we want to make sure that we have clear lines of communication with our client or whoever is authorized to speak or act on behalf of our client. We want to be sure to get as much documentation that relates to our client and the incident as quickly and as securely as possible. We want to make sure that our client is making sound decisions about the litigation and that our client feels comfortable about the decisions being made. So if the client is injured, right, they're still living, and you're able to speak with that person, you want to do that as soon as possible. Now, some things that you want to consider, of course, is the actual ability to communicate. Can the client express to you what is happening, right? And we think about language issues, because it is not just multi-generational African Americans who are being killed by the police, but we also have Black folks that are coming from other countries where English may not be their first language. They may not speak much English at all. It might be Creole, it might be Haitian, it might be Amharic or Tigrinya or Oromo. They may be from Ethiopia or Eritrea. It might be Somali, right? It might be that they're from Ghana, where English is the official language, but they didn't go that far in terms of education to get that language on board. So they speak Tree or they speak Hausa. They may be hearing impaired. They speak, sign language. So we've got to make sure that we address any language issues and that we kind of get this information before we get to the person, if we can. Once we get to the person, or once we, establish that, okay, someone's been injured, someone is reaching out to us, and we've established that we're gonna be able to communicate, we're getting the tools, whether it be translators or otherwise, then the question is, where is the person, right? How do we get to this person? Is this person at a police station? Is this person at an ICE detention center? Is this person in the hospital, right? Or the jail ward of a hospital? Or if not, in a hospital outside of a jail ward, where is the person? And what kind of releases, what kinds of permissions, what kind of letters of representation are we gonna need in order to see that person and to have a conversation? Sometimes we are, for the moment, the only person as an attorney that is gonna be able to get to this person and talk to them, right? They're not letting the family talk to them, including, their spouse or their partner or their children. They're not letting non-family members who they're close to talk to them. You, the attorney, may be the only person. And so we want to figure out quickly where this person is and what we've got to do as attorneys to be able to get in. If the person has been murdered, we still want to be able to figure out quickly how the family can connect up. How does the family get to see the body? How does the family get to make sure that the body of that person is secured, right? So we still want to get that information, which means that we want to quickly determine who is the next of kin or who are the next of kin, who is the designated family member, or if they have no family, that happens, right? They may not have family. They may not have partner, mom, dad, children, none of that. And so it may be a close friend, and we need to find out, you know, who that person is and see if we can get with that person so that we can begin that communication process. When we're looking at folks who have family that is outside of this country, maybe they're here by themselves, as in the case of Brother Africa, who was killed by LAPD here, originally from Cameroon, then you may need to actually reach out to embassies, right? Reach out to consulates to try to see if you can locate family members in the United States or family members that are back in their home countries. You also want to, in terms of ICE, understand that those rules are different. And so if you're not familiar with how you navigate the ICE space and your client has been taken into detention, you want to get with an immigration attorney so you can find that out, right? And so I always tell folks, if we're going to do this work, there's certain people we got to have close to us that we can reach out and touch. And an immigration attorney is one of them. Understand that if the person is living and the person has been injured, that person is going to be traumatized, right? Even if they haven't, you know, they're going to be traumatized. And that means that we need to talk to that person with a trauma cognizant manner. That, of course, includes being supportive, being flexible, right? Listening more than talking. But it also means that we have to remember, and it's a good idea if you haven't already, to take a class or to look online, and you can get information on how it is that you can have conversations with people who are traumatized so as to reduce the harm and the potential of triggering them, right? By having them repeat all of what has happened to them, which has been a traumatic, violent experience, and so that you get the most accurate information. Because what we think is that when something happens to people, that it's so traumatic that they remember everything. And that's not what the science teaches us, right? And so it's important to look at that and to have that information as you are talking with this person. Usually the person is not necessarily used to having an attorney speak to them. And so their expectation about what you should be saying and how you should be talking is not going to be necessarily based on your reality, right? In terms of what you do. It's important, therefore, to start off in the beginning, giving an explanation, a very clear explanation as to what your role is going to be, as to what your core values are, because they don't know you. And there's a bunch of people out here claiming that they love the people and they're here for you, and they really aren't, right? And so you want to intentionally create a relationship, intentionally engage in the building of trust, which is really going to be based upon transparency, right? Being as transparent as possible, your own operations with integrity, which doesn't happen that very second, but they'll see it, right, as you're engaged with them, and the consistency with which you engage with them is going to be important. The other thing to think about when you're talking about communicating with your client is keeping those communications secure. I just, in fact, had a conversation doing an interview for a documentary on the killing of a brother in Wisconsin and the ways in which the police surveyed the family, you know, and we that have been in these cases where our clients, you know, were not killed by the police. We know that the police continue to follow them, sit out in front of their house, bug their phones, all of those things that surveillance means right now. That is possible. And even though what is attorney-client privilege is not supposed to be used, that doesn't mean they won't grab it, right? And use it under the table. And so for us, we talk about using, and we suggest that you use things like Signal. Signal is an encrypted app that you can put on your phone, that you can put on your desktop, your laptop, your tablet, that so far, you know, is as secure as it's going to get. and allows you to share information, share pictures, share documents in an encrypted space. I know out of Hong Kong, they were using Telegram, and so Telegram became all the rage, and I have that also on all of my devices. However, everyone else doesn't. So most people are on Signal versus Telegram, which is why I usually put Signal at the top of the list. And then there's something called Jitsi Meet, Jitsi Meet. Again, Jitsi Meet. And that is like a Zoom, but it is encrypted. I'll tell you from a practical experience, if you are on the phone, it doesn't work as well. So, you know, like sometimes with Zoom, people will have they'll come in video, but then some people will just call in. You who just call in often will not be able to get a good connection. It'll be hard to hear. So if you're using Jitsi Meet, I suggest that folks go and do it as a video, but it is a way for you, especially in this time of the pandemic, when we're talking about social distancing and people are not necessarily going to be able to meet with their clients in person. People are concerned and rightfully so about COVID, especially in the ways that it is ravaging our communities. It's another way that you can have secure conversation, Jitsi Meet, and allow you to see people, because, you know, we want to make that happen. Documentation. You want to look at what does the person remember, right? What do they remember about what has happened? What are the person's injuries? What, when you know, and try, and don't just look at physical injuries, also notice how they're talking, right? Figure out how you can capture and put on paper the way that the mannerisms are, so that you can be able to describe emotionally, mentally, what this has done for this person. Who else does the person think you should talk to about what happened in any aspect, right? And so often all of the information is not going to just be with your client, but your client does have a lot of information about who was there because they were there, you know, about who's going to know some other information, for example, about the cops that were involved. A lot of times those cops are notorious, right? Notorious. Everyone knows who they are. Everyone knows how they act. They have other stories, other violence that's attached to them, other harm that they've engaged in. And so if you can get that information, that is fabulous. If maybe those cops have dealt with this person before, there's some kind of prior incident, all of that are things that you want to document, right? And then keeping what you have and what you document, how are you keeping that secure? I like paper, and I understand. We in this digital age where people want to type everything up, but I don't trust Google and none of them. Yahoo, I don't trust any of them. So I like paper for information that I don't feel like I want to have shared, right? Some of that information I will allow folks to share with me by Signal. So I may on paper have some pieces, or even in the computer have some pieces, but then when it comes to people's names and telephone numbers that I should be able to reach, when it comes to, you know, information about a particular cop, I'm going to try to keep that off of the spaces where surveillance can enter, right? And so there's various ways that folks do that, but those are my ways of addressing the issue of keeping that information secure. As soon as you can get some medical reports, you want to be able to do that. There's, you know, you may need a release depending on how much time has passed. A person might still be in the hospital. And that medical, you know, those medical procedures may be continuing. So you're not going to have this complete list, but you want to try to get that. If the person was killed by the police, then you want to get the coroner's report. You want to get, if you can, and usually the family can help you to do that, right? And so looking at, in this conversation we're having, what can you get from either the person who's been injured or from through the next of kin and others, the next of kin or designated person with the people that, if the person has been killed, those are some of the things that you want to think about. In terms of decision-making, critical issue is how are decisions being made? For so many of us, and not necessarily the folks that are on this call, in this meeting, but for so many of us, there's this thing about client control that people keep trying to get into our brains, right? And that it's important for you to control the client. And if you look at the core values that we have, and especially the value of respecting human dignity, we want to make sure that as much as possible that we're getting client agreement. Of course, ultimately the client needs to agree, right, in terms of the course of action that we take. But we don't want it to be this thing where we understand, because we might be clearer than the client about this decision or the way that they want to go, right? They're saying, I want to do this. And we're like thinking in our heads, that is not going to turn out good, right? But that's where the conversation happens. That's where the communication happens, because as much as possible, we want to be able to be on the same page. Now, while you're talking to the client, there are other people the client is talking to, right? And so I call that the non-attorney decision-making team. They got a cousin, they got a homie, they got big mama, they got an auntie, they got grandma, whoever. They got these other people, someone else who also had a case, right? And so those people may be a part of the person's non-attorney decision-making team, whether it's the person that's been injured or whether it's the next of kin. You want to know who those people are. You want to be able to talk to those people. Again, not sort of like I'm the attorney in an imposing way, but to begin to develop that relationship with them too, right? Because this is not something that just is happening to one person. This is happening to that person and all of the spheres of people that are around them, right? And so you want to make sure that you're having conversations with folks that are in that sphere of non-attorney decision makers, the people that get to put their input. Now, recognizing, of course, that when we have police violence that occurs, that we end up in a situation in terms of investigation in which Bonnie is investigating Clyde. Okay. And we know that, so we understand how this investigation is likely to go. Don't be surprised when your client's family, when that circle of decision makers, when they feel like mysteriously now the police are going to properly investigate how this person was injured or how this person was killed, right? That happens, and it happens often. And if you seem too like anti-cop when they're not in an anti-cop mode, they may be mad at these cops, but they generally are feeling like, hey, they've got to act good because the cops are the ones who are investigating this. Don't be surprised when that happens, and be prepared for that. And to be prepared to push your own kind of energy to the side to be able to recognize and to respect where folks are coming from, right? Sometimes folks are just straight up afraid of the cops. So there's things that they don't want to do. Sometimes they don't want to go public, for example. They don't want to make a big splash. They don't want to make big noise because they're afraid of the cops. And, we can respect that, right? As we know, there are situations in which blowing the case up can be helpful. And there's other situations where you can blow the case up, as in the case of Breonna Taylor, where you have all kinds of people for, almost 200 days, and still the decision goes left, right? Or goes I won't say left is the right direction, goes in a direction that we don't want it to go. And so it's okay if people don't want to take it there, right? Folks may be afraid to go where you might want to go. Maybe when they feel even more disrespected by the police, they'll shift and they'll go in the direction you want to go. But, be prepared to be flexible. Understand also that sometimes folks just need some political education, but they don't need to be lectured. So we need to practice, which we should be doing anyway. How do we talk about the police, talk about the corruption of the criminal sanction system, talk about anti-Blackness? How do we talk about these things with folks who sometimes are afraid to hear it, don't want to hear it, or have heard too much of it, and they're on the, in another sphere where everything's a conspiracy, including you, right? And so doing that work is really important. And you want to know, who the family is, who the team is, the community, the activists, and looking at, all of those pieces and recognizing their importance as you're having these conversations. Now, looking at the family. Our clients often look to their families and their close friends, what I'm calling the squad, for support and guidance, and sometimes for protection. So we're going to run into a lot of brick walls if we ignore or underestimate the importance of family and those close friends and our clients' decision-making and ability to fully engage in this litigation. So we're going to have to navigate those same three areas of communication, documentation, and decision-making with them as well if we're pursuing these cases. One of the first things we want to do is figure out who they are. We talked about that before. We want to look at issues like language to make sure, because it may be a situation in which the person who was killed, for example, was second generation like me, born in the United States. But it may be that their parents, right, or their next of kin, that person is not an English speaker. They're foreign born, right? And they don't speak English. And so that's going to be an issue. And all of those things we discussed before in terms of language, in terms of cultural competence, you want to make sure to take into consideration. Usually, those people are also traumatized, right? Family and close friends, and they act like people who have been traumatized. So the same kind of flexibility, support, awareness, right? Research, skills and tools that we want to get on board on how to talk to folks that have been traumatized. We're going to use that here as well. Usually they also are not used to having an attorney. And so their expectation may be different, right? They see things on TV. They think you're going to be a certain way. You're going to hold press conferences every day, whatever the thing is that's in their mind, which may be different in terms of what you plan to do or what you think makes sense in terms of strategy. And so you can help people to set a new understanding of what the role is of an attorney, and in particular, a movement attorney, right? An attorney that is coming out of a Black liberation praxis. You can help them to get a better understanding through communication of who we are and what it is that we do. Now, they often are required to depend on cops, again, because you have Bonnie investigating Clyde, and they're usually, or can be, nervous about pressing those cops on particular issues. There may be things that you want. There might be demands that you have, you as the attorney, in terms of what you need to move this case forward. This is before you even file a complaint, right? And they may not be willing to go that far. They may need to wait, you may have to wait until they just can't take it anymore. They just have been so disrespected. And they may need some political education. So all of those issues we talked about before still apply, as do the issues of keeping the communications secure. So when it comes to documentation, you want to talk about or figure out what can they tell you about the injured or deceased person that can help, right? Sometimes folks might be, something may come up because we're such a shame and blame society where they feel like, I don't want to tell that part, right? But that part is really helpful. Fortunately, when it comes to mental illness, a lot of that stigma of folks who have been in that world in our community, pushing and pressing for the stigma of mental illness to be taken away, a lot of that has worked, and you see people much more willing to come forward and to say that my loved one who was injured or killed by the police had mental illness, and even in some cases describing more specifically what the mental illness was. or is. And so that's really helpful. There's other areas where people are not so helpful. And so, for example, you have situations where police officers are using their badges. Think about the case out of Oklahoma to pull, people over, claim women over, claiming they're going to arrest them and actually forcibly raping them or forcing them to engage in other acts, right? And so looking and thinking about, okay, sometimes people don't want to talk about that. They don't want to admit that this is what's happening, or this is what they do for a living, or this is what they've been engaged in. And so you want to try to see if maybe the family has that information and can provide that information. The family may know what happened, or they may have heard about what happened. What they heard may not be exactly what happened, right? But there's some clues that you may be able to get from this that enable you to get that information. And then if you have the resources to get an investigator to follow those up, fabulous, right? But it gives you a place to get that information, an additional place aside from your client, if your client is living, because of that trauma, may not be able to describe things in the most complete of ways, right? Find out from them, just as you would from your client, who else do they think you should talk to about what happened? Some other person in the neighborhood, someone that can talk about the cops involved or about prior incidents. The next issue is really important. See if you can get the family to host a vigil, and particularly hosting a vigil in the area where the violence occurred. A vigil, people see not as a protest. They don't see it as something that's going to break out into violence. People that are in that neighborhood or in that area are much more likely and willing to come to a vigil. And often you find people there who are witnesses, either that saw what happened, that heard what happened, or that have seen that cop before, have seen your client before, that can give you some additional information. And so if they don't do nothing else, see if you can get the family and or the squad to do a vigil. And it brings community together. It brings the community together with the family. There are so many positive vibrations and actions that come out of having a vigil, that if nothing else happens, as I said, that the family or the squad can help you to do. Hosting a vigil is a really critical piece. And so you want to make sure that happens. If the area where the incident occurred is one that is like a business area where businesses close at like 6 o'clock, then you want to do it before then, because there may be someone who this is their routine to come by there at that time. Doing the vigil, if you can, at the same time or on the same day and in the same time frame that the incident occurred, is always helpful for that reason, but not necessary, right? And again, anything that you get from them, you want to make sure that that information and that documentation is secure. And then looking at decision making. Teamwork makes the dream work. But you still need to have a point person. So if the person is deceased, we got to have somebody that's going to make the decision. You got to figure this out, and they have to figure it out, the family, early on, with respect to conflict resolution. If there's a conflict between what you want to do, what the family wants to do, or what the family wants to do, and they're bringing in the organizers, right? There's got to be someone that represents the family. It could be political conflicts in terms of like how you think you should move. It could be legal strategy conflicts. It could be media strategy conflicts, right? But you want to decide pretty early and figure out, okay, this is what our process is going to be. It can be flexible. In other words, it can pivot, it can change. But while the process is there, you want that to be the process. You need something that you can point to, that everyone agreed to. This is how we're going to resolve these issues, right? And so you definitely want to have a point person, and you want to have a process. And again, where the family member is the client, you want to make sure to address any potential issues so that you're not in the client control mode. Now, as movement attorneys, we have committed ourselves to uplifting, to supporting, and fighting for our communities. And while we want to connect with community and consider the impact of the litigation on our communities and on the efforts that we have to safeguard our communities, we also have to be mindful that the community's interests and concerns are only part of what we need to consider, because our client is really who we owe the ultimate duty to. There are two communities that we'll talk about here. One community is our client's community, which consists of the people who regularly interact with our client, such as extended family, friends, coworkers, neighbors, club members, right? And the second is the community where the incident occurred, where this law enforcement person committed that violence that resulted in injury or death to our client. And so we still got to look at how we're communicating, how we're documenting, and the decision making that we're doing in that space. So when we're talking about the community of the person who's been injured or been killed, again, we're talking about folks who are usually traumatized because they feel some connection to the person, they know the person, and they're going to act in that way. And so all the things we talked about previously apply. They can be really helpful with helping the person if the person is living, or with helping the family with support. And so to the degree that you can get the family to identify who in this larger community they're rocking with on this, who's the person that's doing the GoFundMe, who's the person that, all of those pieces, you want to do that, right? You want to do that and be grateful for the support. It sometimes is not exactly happening how you want it to happen, but you are not going to be able to do all these roles. And for a lot of times people think you as the attorney are supposed to be like Matlock, and you're supposed to be everything. The investigator, the attorney, the support, the person making coffee, you're supposed to do all these jobs. And so to the degree that other community members can do that the person or the family, feels connected to, you want to make that happen. Documentation, again, they can help with information regarding the person. They might be able to help with information regarding the people involved or other people involved, maybe the friends of the person, whoever else was around. They can help with setting up the vigil, getting the supplies, getting the word out, getting other people there, because we want people who are part of this injured or killed person's community to be at the vigil as well, beyond the family. And then they're not really involved in decision making unless they're a part of that team that I talked about before. Otherwise, usually they're not part of decision making. With respect to the community where the incident occurred, if people are there who witnessed it, they're also traumatized, right? So thinking about the folks who witnessed the murder of George Floyd. They may not be people that know him, that ever heard of him before, etc. They were the people that were there at the time, right? And so, of course, they're also traumatized. And if you're able to get to them, to speak with them, you need to keep that in your mind, right? And do all of those same things that we've talked about with respect to traumatized folks. You want to find out who the community big mamas, uncles, aunties, etc. are that know everyone in that neighborhood, that know what's going on in that neighborhood, right? May not know your client or your client's family, but they know that space to be able to see what information can they give you, right? Because they're a good source of information as well. They can help this community with the incident. They may have conflicting stories to tell, and that's fine. In there are pieces and parts that may prove helpful to your case. They can help with setting up the vigil because they're actually in that space, right? That's the space that they work or the space where they live. And so there may be some help that they can give and might be willing to give. Even businesses sometimes are willing to give some help when it comes to the vigil. You always want to keep your communication secure. And in terms of decision-making, again, they're really not usually involved unless it just so happens that one of the team members happens to live right where that occurred, right? Or their cousin happens to live there. And so their cousin may not be part of the decision making, normally, but now suddenly they are because they've been pulled into the mix. There's a lot of potential conflict of interest issues here. One of them being that you may have some folks, like if it's a neighborhood, for example, who don't want you to have a vigil in their neighborhood because they feel like that's going to bring police, something could happen, because anything can happen when the police are around. They, may not be excited about news cameras and the press coming into their space. Same with businesses. They may not want to be the one that's associated with this incident, especially if someone has been killed. And so you may get pushback there, and you've got to figure out how, again, what's the process that we're using to address those conflicts, not necessarily, not only within the family, the person, etc., but what have you decided you're going to do around people that are outside in this sphere called community? And then quickly, because I only have about 6 more minutes, I believe, looking at the activists and the organizers. So we're movement folk. We're going to feel a strong connection, usually with the politics, the energy, and the commitment of any organizers, activists who might take up our client's situation. And we've got to make the same considerations regarding communication, documentation, and decision-making that we've been talking about. The organizer activists may be individuals, or they may be members of nonprofit organizations, or they may be part of just community collectives and networks. Before you engage, when I say engage, I mean reach out to, talk to, have some kind of connection with the organizers or activists, you want to be sure to research them, right? Research them, see what issues have surfaced or out there about their credibility, about their reputation. You want to do that by talking to the client's family, seeing if they know about them. You want to do your own research. You can Google people. You can see the kinds of tweets and things that have gone out. You can see if there's any articles that have gone out about them. You don't even have to make a judgment in the sense that let's say you see a lot of things that say this person, this organizer or this group is problematic. And you're looking and you trust the sources, it makes sense to you, or you can follow what they're saying is the problem. That doesn't mean you have to judge and decide they're terrible and you're not going to mess with them anymore. But it does mean you want to know that. Okay, you want to know that because you want to be very clear about what your position is going to be, what you're going to express to your client, to the family about how we're going to move forward, or how you think we should move forward with that person or with those folks. And so it's really important, right, that even when we're in this moment of uprising, that, whether it's being televised or not, that we have this opportunity to push the boundaries of the law in conjunction with movement work on the ground. But we need to be mindful of who we're pushing this with, right? Who we're standing back to back with. And we also need to be mindful of not rushing to create bad law, right? As we push these boundaries in an effort to show that we're down and we're not one of those lawyers, who doesn't care, right? That we're clear about our responsibility here. It's very important. With respect to communication, what I want to highlight is that you need to decide, do you want to have direct communication where they're on board and you're really strategizing together, doing a legal community activist organizing strategy, or do you just want to be aware of what each other are doing? That's a conversation that you want to have, obviously, with your client and with the family and the squad, to think about how do you want to deal with that. If you do have contact, you want to make sure that the leadership knows what communication will look like, so that they, in terms of shaping the narrative, et cetera, because whether you like it or not, whether you decide to engage with the organizers or activists or not, they may be the people that are actually moving the narrative and deciding what the narrative is going to be. So you want to make sure of that. Decision making. Sometimes organizers, activists can, documentation, can help with the vigil. And if they can help with the visual, that's fabulous. Again, you want to make sure that this is something that the family's on board with. Let's say the family's not on board. It doesn't mean that activist organizers can't have their vigil, right? They can still do the vigil. And again, you want to be there. You want to have folks be there. You don't have to be a spokesperson. You're really there, not for shine, but for info, right? To try to see what information you might be able to get. And often these activist organizers, they can get some documentation from the state, including reports, because they blow it up, right? They're like, we want the photos, we want the video, we want the coroner's report, we want the fire people's report or the ambulance report, right? And in their doing that, you're able to get some information. You have a lot of organizations now, and Baji's one of them, Black Alliance for Just Immigration, that I'm the ED for. We're doing a lot of FOIAs. And when we get information, hey, we're getting that information to attorneys. If there's no bar against it, we're sharing that information. And that's something that attorneys are then using in their litigation, right? Especially statistical data, et cetera. And so I think it's important, that we do that. And then sometimes these organizations can help you get documentation. The Anti-Police Terror Project and the justice teams in Oakland, for example, they'll go to businesses, they'll ask for video, they'll talk to people there, they act like their own investigating team. And that can be really helpful as you look at activists and organizers. And then looking at decision-making. So it depends on how connected the family is to the activist organizing network. So I know, for example, here in LA with Black Lives Matter Los Angeles, that there are some family members who they really depend on BLM and BLM's leadership to make decisions about even some legal issues that they have, right? And that can create potential conflicts of interest. We don't always have to be completely on the same page, but we at least need to not be in each other's way. And so I'll end with this example. There's a sister here, Waukesha Wilson, who died in police custody, LAPD custody at the LAPD station. The BLM LA and its partners took the position that she had been killed by police in the jail, okay? The attorneys on the case, they didn't feel comfortable saying she had been killed by police in the jail because they didn't have in their mind the evidence to show that. For them, they were enough cool with saying, hey, you're supposed to watch folks. You didn't watch folks. She was, if you're saying she committed suicide, she, is not supposed to be able to commit suicide on your watch. So we'll deal with it in that way. They were able to talk and agree that they were going to have two different narratives, right? And try to figure out language that made it so that the possibility of the other language would still be okay. So they weren't going to say, oh, she was killed by the cops, but they were going to put language in that allowed some space for that possibility. And in the same way with the organizers, they were, going to press the fact that, hey, she was killed by the cops, but they were going to open up the way to be able to make it so that if the evidence just landed squarely on she committed suicide, that they would still be able to have some wiggle room. And so it is possible. Where there's a will, there's a way. Where it's not possible, again, we have to remember that who's at top of mind for us is our client. And so we're fighting on that front line. We're pressing on behalf of our folks as a people. We're pressing on behalf of the community that's been harmed. We're pressing on behalf of the family that's been harmed. But our ultimate legal duty is to our client. Thank you. So folks, I don't know if you have any questions. I feel like I'm putting myself on the stand. I don't know if you have any questions. Let me see. Oh, I don't see a question, but maybe I'm looking in the wrong place. Any questions, folks? I don't see any questions here. What I've gone through and talked through is included as part of the manual. And again, if you don't have that now, the manual that has that piece, you will have it. I can also, if folks want to reach out to me, make the PowerPoint available and you can reach me at attorney, common spelling, Jumphy, GYAMFI, @gmail.com. I'm including that here, and it's in the chat, so you can see that there now. And obviously, you can reach out to us there. So while I'm looking to see, I may need some help from Anne to see if there's any questions. I don't think there are. I will tell you that the code for this section is 0NG4. 0, N like Nana, G like Jumpy, 4. That's the code. 0NG4. That's the code that you want to place on the attendee sheet that you're going to receive from NCBL. So you're going to get an attendee sheet from us. You're going to get it on Monday. And we ask that you fill it out, that you include the codes where it indicated, that you return it as we'll be instructed in the email that you'll get on Monday, and that you then you'll get a certificate for attendance so that you can use that certificate for your MCLE. Laura, you were on for all of them, so I'm going to send you in chat what the conversation is. I'll send you the things there, okay? But yes, so if folks don't have any other questions.
There's a question
Okay, what's the question?
from Demetra. What was the name of the second app you mentioned? I think it was
Telegram. So the three that I mentioned are Signal, Telegram, and Jitsi Meet. Thank you for that question.
there's a comment from Laura. Thank you, Nana. Very nice.
Thank you. Thank you. All right, folks. So while, and actually, if you could help me by sending the codes for the second and third to Laura, that would be great. While we're
I can tell folks.
Okay, go ahead.
The second one was O, meaning 0, D as in David, T as in Temple, 2. Repeat. 0, Donald, Temple, 2. The third,
yes,
was 0, B as in Bernard, F as in Friedman, 3.
Thank you so very much. I want to thank you, Anne, for assisting us on the back end here. It was lovely. Thank you so very much, Brother Donald. Appreciate you. Appreciate Professor Freeman. Appreciate Professor Irving. Appreciate Lennox Hinds, who always makes sure that this comes together and that we are providing the highest level of information as we can. He's very passionate about making sure that we have as many of us out there as possible doing this important work. And I want to thank all of you that stayed through all of this time, and your questions were wonderful. Thank you for all of your comments. We start the annual conference for the National Conference of Black Lawyers tomorrow. And if you have not registered yet, please do go to ncbl.org, ncbl.org, sign up. It's going to be a wonderful conference. It's the first time we're doing it virtually, which actually means that more people can come than normally do, because you don't have to pay for a plane ticket. You don't got to pay for a hotel. And in these times, I cannot tell you what a support and balm it is to speak with, to connect with folks that are, in the battle from all over the country and sometimes even the world. So really, really, really hoping that you folks will register. We have an immigration one that I am hosting that is on Saturday at 2:30, and that's going to be fabulous, talking about Black immigrants at the intersection of racial justice and immigrant rights. But we have discussions about criminal law. We have discussions we're in the international section about Cuba and Palestine. We'll have discussions about reparations and how we make that actionable and bring it into fruition. Questions and workshops about solidarity economy. Whatever it is that is affecting Black folks and is an issue that we need to be concerned about, we're going to have fabulous workshops with knowledgeable, experienced, brilliant presenters giving us the 411 and having the conversation. So again, please go to ncbl.org and register today. Share the information. Let other folks know to register. We look forward to seeing more of you this weekend. Thank you so very much.